Hey, good morning.
Good morning, Mohammed, or Mr. Mohammed, sorry. Okay, I'll let it go. Thanks.
No, Mohammed is fine.
How, yeah, Mohammed or Mr. Mohammed, how are you this morning?
I'm well. How are
Good,
you?
thank you.
Okay, I'm gonna go speak to Mr. Darian Long, but I see Attorney Matthew Forrest is in here.
Yes.
We did come to a resolution already.
And you know what, that's what he said, and the judge is walking out right now, so that would be good. But
Oh,
I don't know if his client is here yet, though.
okay. If you need me, just pull me back in.
Okay, thank you.
Good morning, Judge.
Good morning, sir. How are you?
I'm well. How are you?
Good morning, Your Honor.
I am super. Thank you. Good morning, Miss Medina.
Good morning, Mohammed. Good morning, everyone.
Hey, good morning.
I know we were waiting for Mr. Forrest's client to come on. Have we seen Mr. Malchor?
I'm sorry, Judge, I was looking up attorney's phone number. I have not seen the defendant yet.
All right,
Okay.
I'll
I
log
know
off
he's early, but
call
as soon
her.
as he gets, okay.
All right.
Wait, Mr. Long is at 9:30 and he's here already? Hmm. This is 220774 SM. This is State of Michigan versus David Keats.
Morning, Judge.
Sir, would you state your name for me, please?
David Keats.
Mr. Keats, your case was scheduled at 8 o'clock today for show cause. Pre-trial, the court did have the opportunity to speak to the deputy court administrator. What happened was there was a failure to appear, but this court has since received documentation to show that you didn't appear because you were already in custody. So the
Right.
show cause is lifted. We were going to treat today like a pre-trial, but although the court has called your attorney's office and email, we have not received a response as of yet. And rather than have you tied up sitting here waiting, what we'll do is we've already lifted the show cause. We'll recall the warrant in this file. We'll adjourn this matter over, Mary Ann, for 2 weeks to give us time to get notice out to Ms. Silver's office.
Okay.
Yes, March 13th, it'll be at 8:30.
This case hasn't already been, what do you call it? Thought this case was already over with. I might be mistaken, but that's what I thought, I assumed.
I know, Mr. Keys, I'm going to suggest that you don't say anything right now since Ms. Silver is not here.
Okay.
I know they were trying to resolve it as a part of a larger issue, but at this time, this case is not resolved. We're putting it over for pre-trial on March the 13th at 8:30 a.m. That will give you time, that will give the court time to get notice to your
Okay. And that you said that
attorney.
now you said you were lifting the warrant.
The file's in warrant status for your failure to appear, but the court has since received proof that you were already in custody. So it wasn't a failure to appear.
Okay. Because this deputy said that I was in warrant status.
And that's why I said I'm lifting the warrant
Okay.
on this file.
I didn't understand. Okay.
I'm sorry, Mr. Keys, maybe I'm not saying it clearly.
No, I hear you.
This court is lifting, we're lifting the warrant. Ms. Kraus, thank you.
Good morning, Judge.
Good morning. Mr. Keys, I just called the case to lift the warrant to indicate to him that this case is not in show cause status and to set a pretrial for March the 13th.
Judge, this case was actually dismissed as part of a plea agreement at the circuit court.
The problem, Ms. Kraus, is I'm looking in the file. And no one's relayed that to this court. I know that we had adjourned it before, and the indication was that it was supposed to be resolved as part of a larger global resolution, but nobody sent notice of the dismissal to 34th. So if you have that information, if you can show where that occurred, I'm happy to enter a dismissal of this case, but I don't show that we received any information that that is what happened.
Okay, I can contact the APA on the case. I can also send the court a plea form.
Then let's do this. Mary Ann will send you her email address. That's my secretary. If you would email it directly to her, the plea form that shows that this case has been resolved, I'll do that, and you won't need to appear. Your office won't need to appear on the 13th, okay?
Thank you very much.
Thank you, Ms. Kraus. Do you need to speak to Mr. Keats at all?
Keats, do you need to speak to me?
I'd love to.
Okay.
There we go. Thank you. Give me 1 minute, Mr. Long.
Hey, Judge.
This is 2400.
I'm so sorry. Was that last case David Keats?
Yes.
So I just received the text message saying that to relay to the court that from Patricia Mandernich, APA, that the case should be dismissed pursuant to a circuit court plea.
Thank you.
From those and stuff.
Is Mr. Gagniak waiting to speak to you about Mr. Comstock? This is 240039 SM. This is State of Michigan versus Darian Long. Sir, would you state your name for me, please?
Darren Long, ma'am.
Thank you. Mr. Long, the way the court staff have you labeled indicate that you're waiving your right to have the assistance of the court-appointed attorney this morning. Is that correct?
That is correct, ma'am.
Sir, the court is in receipt of a plea form from APA Assistant Prosecuting Attorney Mohammed that indicates that you will be tendering a plea of guilty to count 1, brandishing in public, and count 2, and count 3, assault or assault and battery, and that count 2, assault or assault and battery would be dismissed, that the brandishing plea would have a delayed sentence for 12 months, and the assault and battery will have a delayed sentence for 4 months. Was that your understanding, sir?
Yes, ma'am. My understanding would be that those sentences would be delayed, and as long as I don't have any criminal interactions, those cases will be dismissed.
Okay, Mr. Long, the other issue is that before I swear you in and take the formal plea, I want to disclose to you that I'm married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the issuing agency in this case, the police department involved in this case. My husband is not involved in the day-to-day operations of the public safety department. He doesn't know anything about your case. He doesn't even know that it's scheduled. That disclosure having been made, sir, are you prepared to enter the plea this morning, or would you like this case assigned to another judge?
No, I don't question your integrity, ma'am.
Mr. Long, would you raise your right hand for me, sir? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind.
Yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes, ma'am.
And sir, you're entering this plea freely and voluntarily?
Oh, yes, ma'am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
Nothing other than what I stated, ma'am.
Are you pleading guilty, sir, because you are in fact guilty?
I'm going to say no, but it is expedient and reasonable.
No, sir, we don't do expedient here. If you're not pleading guilty because you are in fact guilty, we can set this matter for pretrial. You can come back, you can have the opportunity to speak to a court-appointed attorney. You may retain your own counsel and appear back. So how would you like to proceed this morning?
I would still like to proceed with the plea, ma'am.
So I'll ask you again, Mr. Long, are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Mr. Long, is it true that on October 6, 2023, that you did brandish a firearm in public in.
Yes, ma'am.
Is it also true that on that day, October 6, 2023, again in Van Buren Township, that you did make an assault or an assault and battery upon one Zachary Deniston?
Yes, ma'am.
Mr. Long, the court will accept your pleas as to count 1 and count 3. Count 2 is dismissed. As indicated by the form submitted by the prosecutor, the sentence for count 1 is delayed for a period of 12 months, again, so long as you incur no new criminal offenses in the state of Michigan during that 12 months. The case will be administratively reviewed for dismissal. As for the assault, the court will impose costs of, I'm sorry, hold on one second. Okay. As for the brandishing, sir, let's start with that. Is there anything you'd like to say before the court assess costs in this matter?
I wasn't aware that there were going to be any fines and fees.
What did you think would happen, sir, as a result of you pleading guilty to brandishing a weapon and assaulting somebody?
Well, we agreed upon a delayed sentence. That's what we agreed upon.
And Mr. Long, I will ask again, if that's not what you wish to do this morning, we can reschedule this matter. You can have the opportunity to either retain counsel of your own or appear at the next pretrial date and speak to one of the court-appointed attorneys. It's up to you.
I understand that, Judge Martin. I just wasn't aware there were any fines and fees.
Then let me finish. I'll read the full sentence agreement. In addition to the pleading to the brandishing with a 12-month delayed sentence and a 4-month delayed sentence to the assault and battery, during this period of time, defendant is to commit no crimes or violations in this or any other venue in Michigan. Following a successful completion of the specified period and upon payment of costs assessed by the court, the plaintiff prosecution recommends dismissal under MCL 771.1. And he indicates that you will take anger management classes and other terms set by the court. So that being the case, Mr. Long, what are we doing this morning?
I guess we're going forward, Your Honor.
Thank you. Mr. Long asked for count 3 assault and battery. The court is imposing costs of $400 and for the brandishing $100. That's a total of $500. Sir, do you need more than 5 days to pay this amount?
I need 30 days, ma'am.
30 days to pay and anger management as indicated in the agreement offered by the prosecutor. Mr. Long, did you verify your address and phone number with court staff this morning?
No one asked me. And so it's my understanding am I to take these anger management classes within 30 days as well, ma'am?
No, you need to take them before the end of the delayed sentence, sir.
Okay.
Mr. Long, we have you on O'Hara Drive. Is that still a good address for you?
That is, ma'am.
Okay. Anything else this morning, Mr. Long?
No, it's been quite enough, ma'am. Thank you for your time.
Mr. Long, have a good day. Good luck to you, sir.
Yes, ma'am.
Good morning, Mr. Jadala. Are we ready with Mr. Comstock?
Attorney Brian Gagnick here. I need a special attorney or a prosecutor on this matter. May I also have a breakout room with him right quick? Please.
You need a special prosecutor?
Yes, it's a CSC in the first degree. It's not a courtroom prosecutor situation.
Have you been in contact with the prosecutor?
Not on this one. It appears what I just found out, it could be Jacob Bloomers. And I just found that out.
Judge, I can send APA Ripley and APA Bloomers an email letting them know that the court is looking for them.
Would you please?
Thank you, Judge.
And in the meantime, oh, you know what? Yeah, in the meantime, we need to get Mr. Gagnon in with Mr. Comstock.
White box and blue will say join. That'll be the breakout room for attorney. Is there free to be on the ground, the speaker, put it to your left here.
Mr. Dubin, are you ready with Mr. Konowalski?
Oh, there it is.
I don't know.
Good morning, Mr. Martin.
Good morning, Judge Martin. I was just speaking with Mr. Muhammad. I have a few cases this morning. Most of them are set or at 9:15 or later, but I had one at 8:45. His name is LaJohn Vinston. He's in Washtenaw County Jail, so I don't know if they've checked in yet.
I have not seen them yet, Marianne.
No, ma'am.
Okay. Well, then I might have to step away and handle some Frank Murphy matters, and I'll come back as soon as I can.
Thank you, sir.
Thanks.
Good morning. I'm sorry, you are? I'm good. And you're wandering into the courtroom for the court's file or?
Yeah, the prosecutor sent me in from Mr. Saunders' court file.
No.
No.
No, the court file is not leaving the courtroom on the day of the docket. What is specifically are you looking for?
As for the file, we're going to, my client's going to take.
Okay, and why do you need the court file is what I'm asking.
I don't know. He
didn't tell you?
No, I'm sorry.
No, it's okay. I'm just curious because we don't typically.
Well, yeah, he said he couldn't get it. I don't know. Want me to send him in?
No, he can come on and tell me what he needs out of the file.
Gotcha. Okay.
I mean, the only thing we have in here is the citation, so that's not going to be particularly helpful.
Okay, we've got the discovery packet.
No, it's not. We don't
Not
have
here,
that.
but yeah, okay.
Thank you. Mr. Forrest, have you reached your client as of yet?
I have not, Judge. Her phone is going straight to voicemail. I don't know what's going on. I spoke to her yesterday afternoon. Thought we had this lined up. I don't know.
A for effort. I don't take failures to appear till the end of the docket if you want to keep trying to reach out to her.
Okay. And I'll log back in.
Thank you.
Thank you, Judge.
So the reason I need the file is to confirm that this is an OWI first, because we don't have anything on the system for these kids.
Mr. McKinney,
okay,
you need
I don't
to
know
join the
what that
breakout room,
means.
please.
The plea is essentially going to be in the chairs.
Mhm.
I just want to confirm that it's OWI first before I make that offer.
What would help you confirm that? The citation that says OWI? or the criminal history that doesn't show anything else.
Mr. McKinney, if you can hear me, you need to join the breakout room, please.
We don't have a file on the system in this case, like it's not a PDK.
How?
I don't know.
That's interesting.
It's written up as a ticket, I think.
You're not leaving with that. You're gonna hand it back to me.
Yeah, of course. Yep. Thanks.
Oh. We're all set. Thank you so much.
Can my attorney hear me?
I haven't seen your attorney yet this morning, I don't think. Give me 1 second, Mr. Williams.
No, I don't believe so, Judge.
I don't wish. Yes, Miss Medina.
Oh, hi. I was just, letting you guys know I'm still here.
You're just
Hola.
hanging out?
Yep. Making better choices for breakfast today. Donald's versus granola and Greek yogurt. That's about it, Judge. I'm here. But
Making better choices. I love it.
Making better choices.
No, we're waiting patiently for defense attorneys to appear.
Well, this is the great part about Zoom. We can all, kind of wait patiently.
We can all hang out
with other
and
paperwork.
wait for stuff to happen.
Yes. Thank you, Your Honor. I appreciate it.
No worries. Good to see you.
Nice to see you as well, Judge. Always.
And Marianne, no contact from Ms. Tieppo?
That's correct, Judge.
No, what I don't know. The attorney listed for Comstock, the prosecutor is Tina Ripley.
Yeah, I don't know. I didn't know that there was a special. Do you want me to? I wonder if Miss Niemann got it.
I thought she would, I thought she was trying to,
Yeah.
and now she's gone, so I'm not sure what's going on. I'm sorry, Mr. Gagniak, did you say you had or had not been in contact with the prosecutor?
Your Honor, I have not been. Just as regular course of business, I usually do not know who the prosecutor is, but sometimes before a case like this, at this stage.
Okay. The ROA shows it as Tina Ripley, and I know Marianne is reaching out to Ms. Mandernack to see if she can get them on.
That sounds fine, Your Honor. I'm here.
Thank you. Mr. Dubin, are you ready with either of your files, sir?
Your Honor, I'm ready with both of my files if you are.
This is 230770 SD. This is State of Michigan versus Timothy Konowalski. Your appearances, please.
Good morning. Good morning, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Mr. Konowalski, who appears via.
Sir, unmute yourself and state your name for me, please. What? I know he was just here.
Oh no.
Mr. Dubin, let's see if he reappears.
I'm sure that was a mistake, Your Honor.
Take your hat off, please. Do you have the plea form for Mr. Muhammad? Yes. Thank you.
Your Honor, if it helps, we're asking for one final adjournment to discuss a final resolution in this matter. We believe him.
I'm sorry, I cut you off. You were saying you believe?
Yeah, it should be resolved by the next court date. We're asking for just for one final pretrial for this. It's just set for pretrial. It was set for pretrial today. We're just asking for one final pretrial because I know the court wants to keep this moving.
How long of an adjournment, sir?
Whatever is suitable for the court should be perfect for us, Your Honor.
No, sir. 1, 2, or 3 weeks?
2 weeks, please, Your Honor.
(9:00), Judge, on March 13th.
Thank you. March 13th at 9:00 in number 2 in person with Judge Oakley. Anything else in this case, Mr. Dubin?
No, Your Honor. Thank you very much.
Thank you. This is 23HR10909A. It's the State of Michigan versus Jacob Saunders.
Good morning, Your Honor.
Good morning.
Bernadette Castro on behalf of the defendant, Mr. Jacob Saunders, P number 70997. Let the record reflect Mr. Saunders is speaking to my left.
Thank you. State your name for me, please, sir.
Jacob Saunders.
Thank you, Mr. Saunders. Today is the day and time scheduled for the adjourned pretrial in this matter. The court is in receipt of a signed stipulation to amend count 1 to operating while intoxicated, from operating while intoxicated to operating while impaired, plus alcohol and treatment classes, other terms and conditions by the court. Was that your understanding, Ms. Castro?
Yes, that is correct, Your Honor.
Thank you. Mr. Saunders, raise your right hand for me, please, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yeah, I do.
Thank you. You've had the opportunity to discuss this case with your attorney. You understand the charges you face and the possible penalties.
Yes.
And after having that conversation, sir, is your intention this morning to plead guilty to the amended count of operating while impaired?
Yes, ma'am.
And you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes, ma'am.
And sir, you're entering this plea freely and voluntarily?
Yes, ma'am.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Sir, is it true that on November 1st, 2023 in Huron Township, you operated a motor vehicle while you were visibly impaired by some intoxicant?
Yes, ma'am.
Ms. Castro, would you like to inquire further of your client?
Your Honor, I just very briefly, on that day that you were arrested, can you tell us what were you bringing?
A couple shots of vodka.
All right, and then, Mr. Saunders, are you currently working?
Yes, ma'am.
Okay. Where are you working at?
BASF Wyandotte.
Okay, I got you. All right, very good. And then, I believe that you are, how do you feel about this? Are you remorseful or sorry?
I'm sorry, Ms. Castro. Your last question to him was?
Yes, if it was remorseful or sorry about what he did.
Yes, ma'am. I won't happen again.
Anything else? Thank you, Mr. Saunders. The court will accept your plea of guilty to the added count of operating while visibly impaired, dismiss the original charge in this matter. Because this is a drinking and driving offense, Mr. Saunders, what the court will do is refer the matter to probation. They will interview you and develop a sentence recommendation. They will then schedule you to come back here for actual sentence to be imposed. They will be in contact with you by phone and by email, so please respond to their efforts to be in contact and communication with you, okay?
Yes, ma'am.
Anything else, Ms. Castro?
No, Your Honor.
Thank you very much. I'll see you at sentencing. Have a good day. Good luck to you, sir. Yes, Pravanchi?
Good morning, Your Honor. Are we concluded with Mr. Comstock or?
We have not. We're still waiting for the APA to come on. Looks like we've left messages. I'm sorry to hold you up, sir.
Oh, then that's fine, Your Honor. We'll wait for the longer.
Thank you. I appreciate it. Mr. Dubin, I was looking for Mr. Redding. Oh, Mr. Konowalski is back, but sir, we've adjourned this matter over.
Mr. Konowalski will call you, okay? You can log off.
Okay.
I got it taken care of. I'll call you after. You can log off. Thank you, Mr. Konowalski.
Thank you.
You're welcome.
Mr. Amadeo, are you ready with Mr. House?
Good morning, Your Honor. Yes, we are.
These are 240010 FD and 230328 FD. These are State of Michigan versus Dennis House. May I have your appearances, please?
Good morning, Your Honor. William Amadeo, P7619, on behalf of Mr. House. We both appear via Zoom. Waive a right to be present in person. Thank you for allowing the Zoom. Dennis, please state your name so Judge Martin and her staff know it is you.
Okay, my name is Dennis Michael House,
Okay.
Your Honor. And what else did you want?
That's it, Dennis. Thank you.
Thank you. Today's the day and time scheduled for the PCC in these matters. Mr. Amadeo, how are we proceeding?
Your Honor, today we're going to be waiving our right to preliminary examinations. This has been explained to Mr. House. We're going to move to circuit court for further resolution.
Thank you. Mr. House, raise your right hand for me, please, sir.
Sure.
Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
Thank you. May I put your hand down? Sir, you had the opportunity to discuss this case with Mr. Amadeo, and you understand that you have an absolute right to have a preliminary examination in this matter, where the prosecution would have to show that both a crime had been committed and that probable cause exists to believe that you were involved in the commission of that crime.
Yes, I understand, Your Honor.
And after having that conversation, sir, you wish to waive your right to have such an examination.
Yes, I do, Your Honor.
And sir, you're doing so freely and voluntarily?
Yes, Your Honor.
You haven't been threatened in any way or promised anything to get you to waive the exam?
No.
Thank you. And Mr. Amadeo, because you appear on Zoom, there is not a signed waiver form in the file. Do you authorize the court to sign the waiver in both matters on your behalf and on behalf of your client?
Yes, and thank you for doing so, Judge. We consent.
Thank you. Mr. Mohammed is not in this main session, so I cannot acquire of him, but Mr. House and Mr. Amadeo, the court will accept the waiver as being freely and voluntarily given. We'll cite it on your behalf and on behalf of your client. Mr. House, as indicated by Mr. Amadeo, the next step in these proceedings is that you will be bound over for arraignment on the information. That will occur at the Frank Murphy Hall of Justice on March the 13th, 2024 at 9 a.m. Your previously entered bond with any of its conditions will continue. Excuse me, Mr. Amadeo, was there anything else in these matters?
No, thank you, Your Honor.
Thank you. Mr. House, good luck to you, sir. You're free to go. You have a good day. Nice haircut.
Thank you, Your Honor.
Have a good day, Judge.
Mr. Janala, what are you ready with, sir?
Your Honor, I have a 9 o'clock for Mr. Abdul Latif, who I don't believe has checked in yet. I also have a traffic matter that I've resolved, and I also have a 9:45 that I'm early for. I was wondering, should I log back in at 9:45 to see if my 9 o'clock has arrived back then?
That would be great. Thank you, sir.
I will be logging back in about 25 minutes, Your Honor.
Thank you.
Thank you.
Here we go.
Morning, Mr. Batar.
Good morning.
Do you need a breakout room with the prosecutor?
Yes, please.
Okay.
Your Honor, I'm sorry, I just can't recall. Did you say my client Redding, the court was waiting for the file, or my client wasn't on?
I pulled the file out because I saw your name. I have not seen Harmony Redding this morning.
Okay, Your Honor, we are going to be adjourning that one too. If we do need her and she's having trouble, can I step away and call? But I was asking for, she has been accepted in sobriety court and her deviations with Judge Hathaway. So I was just asking for another final PCC. I was just going to request that you do it on the same day so I can take care of both of these cases when I come in March 14th.
Give me 1 second. I'll call the case and we'll just adjourn it over to that same date.
Thank you so much, Your Honor. I really appreciate it.
No worries. Were you expecting her this morning?
I think so, but her phone's having trouble. So I don't know if she's having trouble with her cell phone bill or what's going on, but I know we were talking to her yesterday.
I was gonna say, give us just a minute. There's somebody in with the clerks who's not identified. They're trying to get their audio connected.
Okay.
This is 230781 FD, State of Michigan versus Harmony Redding.
Good morning, Your Honor. Attorney Maxwell Dubin, P number 86012 on behalf of Ms. Redding. Your Honor, today's the date and time set for PCC. We're asking for one final PCC. My client has been accepted into and will be allowed into sobriety court in Ypsilanti. She does have a deviation in front of Judge Hathaway currently. I have talked to the prosecution in this matter. We are just asking for one final PCC, Your Honor. I would request the March 14th date. I believe it's 9 a.m.
March 13th.
March 13th, excuse me. Pardon me, Your Honor.
Nope, I just want to make sure you're not here on a Thursday.
Yeah,
March 13th, Marianne, is there still space at 9 o'clock?
Yes, ma'am.
9 o'clock in number 2 with Judge Oakley in person. Is there anything else, Mr. Dubin?
No, Your Honor. I hope you and your staff have a wonderful rest of your day, and thank you as always.
You too, thank you. Mr. Bazzi?
Good morning, Your Honor.
Good morning. What are you here for, sir?
SNA Express. We're just setting up our final pretrial.
24RP00528SM, State of Michigan versus SA Express. How long before the final pretrial, sir? How many weeks are you asking for?
Just a few weeks, Your Honor. You know,
A few is 1, 2, or 3.
3 weeks is fine with us. Would that be
March 20th at
13?
9 o'clock.
Judge, I have
3 weeks
I have
is
a
the
jury
20th.
trial.
Are you talking the 4th? You have a jury trial on which one of those dates, sir?
The 20th
So you want the 13th?
or the 27th, if you don't mind.
The 27th at 9 o'clock.
Thank you.
27th at 9 o'clock in number 3 with Judge Green. Anything else in this case?
Thank you, Your Honor. Have a good day to you and your staff. I appreciate that. Sorry for the interruption.
You too, thank you. No worries. Mr. Gagniak?
Yes, Your Honor.
And 240094 FY, State of Michigan versus Eric Comstock.
Brian Gagnick, Your Honor, Neighborhood Defender Service, P64220.
State your name for me, please, Mr. Comstock.
Eric Comstock.
Thank you. Although this court has reached out to the assistant prosecuting attorney assigned to this case, that being Tina Marie Ripley, this court has not received a response back. This case was scheduled at 8:30. It is now 9:29 by this court's clock. The court does not want to keep the Wayne County Jail tied up. Mr. Gagniak, how are we proceeding in this matter this morning?
Well, Your Honor, I would be otherwise asking for a preliminary examination date. I'm available next Thursday or the following Thursday. I believe I have most, if all, of the discovery, so I am prepared to proceed.
There's two problems, sir. Number one, that the court does exams on Wednesday except by agreement between the parties. Number two, there's 3 issues. Number 2, this occurred in Van Buren Township. Before we schedule an exam involving Van Buren Township, I want to disclose to you on the record that I'm married to an elected official in Van Buren Township. He's not involved in the day-to-day operations of the Public Safety Department. He doesn't know about Mr. Comstock's case. He doesn't even know that it's scheduled. So I would like you to have the opportunity to speak with your client, should you so wish, regarding that disclosure.
Yes, Your Honor.
And number 3, the third issue is that this court does not have a felony docket again until April the 3rd. If you and Ms. Ripley agree to a different date, the court will be happy to schedule it for that date. But unless you're willing to wait till April the 3rd.
I'm not, that is quite a ways away. Your Honor, Would the court allow me to wait around for Miss Ripley, allow me to waive my client's presence? He does know what I'm trying to accomplish today. But I would also take that breakout room to discuss the issue about Van Buren Township.
Thank you. So answer to your question is yes, Marianne will get you and Mr. Comstock back into a breakout room after you discuss the disclosure with him. You're happy, I'm happy to have you wait around as long as you want for Miss Ripley, but I just don't want to hold the jail.
I certainly could provide a phone number, but I will discuss all issues and I'll make myself available when Miss Ripley becomes available.
Thank you, I appreciate that. Ms. Tieppo, are you ready with Mr. Taylor?
Your Honor, I am ready if Mr. Taylor is still on the Zoom.
Oh. What? Oh.
Don't see him,
Ms.
Judge.
Tieppo, I don't see him and he had been here.
Yeah, he told me he was in the waiting room.
He wasn't in the waiting room. He had been in this main session since 8:30, 8:40 maybe.
There's an unidentified person in with Heather.
Okay, give us one moment. Let's see if this is him. Ooh.
It is not.
These are 23L547797 AOT 200095 FY 200096 FY 200097 FY and 200094 FY. These are all state of Michigan versus Matthew Mark Taylor. Your appearance, please, ma'am.
Yes, good morning. Rebecca Chiappo, P62311 on behalf of Mr. Matthew Taylor. I would ask the court to waive my client's presence at this time. He was logged in to this session and I'm not sure where he is at the moment.
Thank you. The court will waive his presence, noting that he was here previously for approximately 1 hour. Ms. Tieppo, you've had the opportunity to speak to Mr. Mohammed. How are we proceeding in these matters?
Your Honor, we would like to schedule all 4 cases for preliminary exam.
That date would be the April 4th date at what time? I'm sorry. April 3rd date at what time, Marianne?
At 1:30, Judge.
All right.
April 3rd at 1:30.
Sounds good. Thank you so
And
much,
if he
Your Honor.
logs back on, I'm sorry.
Yeah, I just said thank you so much.
Oh, you're so welcome, Ms. Tieppo. If he logs back on, we'll give him that date and time.
Thank you.
Thank you.
Okay, bye.
Bye-bye.
I was just here, but Agent Russell called me back. He wanted this piece of paper. Yeah, he wanted this piece of paper.
do you have some of these?
I do, I'll bring some in.
Thanks.
The blue?
The blue, yes.
I'll get some more
Thank
later
you.
for you.
I'm all done. Well, gotta make sure with the judge.
Your Honor,
Bonchi, I think we're done with Mr. Comstock. Thank you.
you're welcome, Your Honor. You and your staff have a wonderful day.
You too. Good to see you.
Thank you, ma'am.
Your Honor, Brian Gagnick here. Is there someone I can provide my phone number to so I can log back on at the right time?
Absolutely. In the chat to Mary Ann.
Got it.
Give me 1 second, Mr. Bitar, please.
Judge, do we have APA Mandernack available?
She was here and she left. I don't see that she's back.
Okay, we're just waiting for a complainant on Anderson. Hanson, I need to go back and talk to the prosecutor after he talks to the complainant.
Mr. Taylor?
Yes.
Ms. Tieppo did appear and advised that these matters were to be set for exam, and we scheduled them for April the 3rd at 1:30 p.m.
Okay, I think she just texted me. So what was said? So
Okay.
I prefer to have had the case because I don't know what was said or anything, Judge. I didn't agree to that. I was in the
We
room.
need to get her back
I got
on.
here earlier. I mean, you don't have to. I
I know,
understand trying to
Mr.
get her, but
Mr. Taylor, no, I told her that you were here and I'd seen you. And when she appeared, and I told her, I said, if he comes back, we'll give him that date and time. Did you
yeah, I
not
had
agree
some
for
type
these
of
cases to
connection.
be
I
set
don't
for
know what.
exam?
Yeah, I don't know what happened with my thing. It just logged me out, and I'm guessing all that happened during that time.
No, it was only a second. Let's see if we can get Ms. Tieppo back on.
I mean, you know, that's fine. If you got, as long as I don't got a warrant put out, if I appeared, that's what I was saying. You counted as peer, so I'm supposed.
Oh, no, Mr. Taylor, I saw you were here. And when I called the cases,
Okay.
I said he must have just left. And we just put him the exam with the witnesses and testimony on April the 3rd at 1:30.
Okay. Okay. So I won't have a warrant.
And notice no warrant. Notice we'll go out to you at the address we have, okay?
Yeah, that's fine. The 2-3. Yep. I don't need to speak then. I'm sorry about that. I didn't
You don't need
understand what
her?
you were saying.
Okay.
Yep.
I'll see you
I
in
understand.
April,
I'm
sir.
fine with
Take
that.
care.
Thank you.
Mr. Lee, Mr. Arnett is here. Do you need to speak to him? Oh, did you move him that fast? Okay. This is 2307999 SM. This is State of Michigan versus Victor Stokes. Your appearances.
Crystal Marie Medina, Your Honor, on behalf of Mr. Stokes. Mr. Stokes, go ahead. I'm sorry about that, young man.
I'm sorry, Victor Stokes.
Thank you, Mr. Stokes. Today is the day and time scheduled for the pretrial. Ms. Medina, how are we proceeding?
Your Honor, I do believe that APA Mohammed sent over a plea form in this file. I just wanted to note that with regard to that plea, we had discussed a no contest plea, and that is what my client will be entering today. He is 23 years old. Unfortunately, the people are not consenting to hide out given the complainant's perspective on things, Your Honor.
I'm sorry, Ms. Medina, it doesn't say no contest.
I did speak with, I can have maybe APA Mohammed come out of the breakout room a second.
Well, what's the basis for the no contest plea?
Potential civil liability, Your Honor. There was, according to the report and pictures provided, there was physical injury as a result of the altercation, Your Honor. And I did confirm that there was no objection from APA Mohammed. I am texting now, Your Honor.
I'm sorry, and is the victim here?
I am not sure if they're here today.
Okay.
They have appeared in the past, Your Honor. They were in person at one point when I was in.
I guess the court's concerned with the no contact plea, I'm sorry, with the no contest plea, allowing the victim an opportunity to be heard. That would only impact having sentence imposed today. That's my concern, Ms. Medina.
Well,
the court will take the plea, but it's just that aspect.
Yes, and I think APA Mohammed has spoken to him extensively. His recommendation, I think, was the anger management. But what we could do is also just wait for APA Mohammed to go on the record with us on this one. I think that might be best, Your Honor. I don't want to miss.
Okay.
Thank you.
Oh, I appreciate that. Mr. Stokes, if you would just wait a moment when Mr. Mohammed brings himself back into this session, we'll recall the matter. This is a recall of 24009-4FY, State of Michigan versus Eric Comstock.
You want me to leave?
No, just mute yourself, sir.
Oh,
please.
okay.
In the Comstock matter?
Good morning, Your Honor. This is Jacob Bloomers on behalf of the people, P77307.
Oh, he's here. Mr. Bloomers, this case had previously been called. Mr. Gagnac is here and was asking for the exam to be scheduled.
It appears he's still in the gallery, but
he's not responding.
Yes.
He's not responding, but if you don't mind sitting tight for a second, if he
Absolutely,
responds
Judge, I'll
to
stand by.
efforts to get, okay. Oh, Marianne. Mr. Bitar, are we ready with Mr. Anderson?
We are, Your Honor.
This is 2400072 SM. This is State of Michigan versus Christopher Anderson. Your appearances.
Good morning, Your Honor. Daniel Bitar on behalf of Mr. Anderson. Mr. Anderson, can you unmute yourself and state your name for the record, please?
Christopher Anderson, Sr.
Thank you, Mr. Anderson. Today is the day and time scheduled for the final pretrial. Mr. Bitar, how are we proceeding?
Your Honor, I talked to APA Mohammed, who spoke with APA Mandernack. The complainant has failed to appear, is not going to appear. We're moving to dismiss.
This case having been scheduled at 8:30, it now being, I'm sorry, this case being scheduled at 9:30, it now being 9:51 by this court's clock. Complainant having failed to appear, defense motion to dismiss is granted. Is there anything else, Mr. Bachar?
No, Your Honor. Thank you.
Thank you. Mr. Anderson, that concludes this matter, sir. You're free to go. You have a good day. Don't leave. Don't leave. Sign these two right here for me, please.
Thank you, ma'am.
Thank you, Mr. Anderson. Ms. Medina is here with, yes. Is that no contest? You need a moment?
Yes.
Okay, and in that moment, Mr. Gagnac and Mr. Bloomers, this is the recall of 240094 FY, State of Michigan versus Comstock.
Jacob Bloomers on behalf of the people, P77307.
Brian Gagnick, Your Honor, Neighborhood Defender Service, P64220. Your Honor, may I waive Mr. Comstock's presence, please?
Yes, sir. When I called the case before, I did advise Mr. Bloomers that Mr. Comstock had been present. Mr. Bloomers, is this your case going forward, sir?
Yes, Judge, it has been assigned to me.
Thank you. Mr. Gagnac has requested that the exam be scheduled. This court's next regular exam date is not until April the 3rd. Indicated to him that if you two could agree to a different date, we could schedule it at a different date, an earlier date.
Well, I will say April 3rd is the defendant in custody or out? Out.
He's in custody.
He's in, okay.
I'm listening, Your Honor. I'm stepping away just to grab my calendar. Your Honor, one other matter involving this court handling this matter based on the relationship with Van Buren Township. We have no issues with that. My client is not concerned, and neither am I.
Thank you. Mr. Bloomers, when would you be available, sir?
Judge, I'm looking, I mean, you know, I have dates here and there. I don't know if you want me to just start rattling off or if you want to look at a particular week.
Let's start with a date, first date.
Okay. March 11th or 13th.
I'm available.
Not March 11th. Not March 11th. Are you available on March the 13th? Why does that sound like a bad date, Marianne?
Because you do have, let me check your calendar. I know you have first hearings. Let me check the timing on that. Your last one is at 1 o'clock that day. I don't know about backup for me on that day.
The next date after that, Mr. Bloomers?
The following week I could do, that's the week of the 18th. I can do any day except Friday, the 22nd.
Mr.
I'm available as well that week.
Are you available on the 19th?
That's good for the people.
Yes. I am available the 19th.
Marianne, would you check to see if somebody's available, please?
I'm doing that right now.
Thank you. Mr. Bloomers, how many witnesses do you anticipate?
I would anticipate just the complainant, but there could be a second short witness to shore up a couple things, but likely just the one.
Mr. Gagnon, do you anticipate any witnesses?
No.
All set, Judge.
The 19th at
I'm available
9 a.m.?
anytime. I can accept 9 a.m. on the 19th.
I can do that, Judge. One other matter regarding discovery, there is a kids talk. There will need it to be a protective order put in place. Mr. Gagnick, do I have your permission to sign that protective order?
Yes.
Okay, thank you. And then, Judge, if the clerk could just put their email in the chat so I can send that protective order onto the court for signature.
Absolutely.
Thank you, Judge.
March the 19th, that is the Tuesday at 9 a.m. Mr. Bloomers, what Mr. Gagnick was referring to is I made the disclosure before you appeared that I'm married to an elected official in Van Buren Township. That's the police agency involved in this matter. My husband's not involved in the day-to-day operations of the public safety department. He doesn't know anything about this case. He doesn't even know that it's scheduled. Your office has been made aware of this relationship previously. Are you still prepared to proceed with the exam on March 19th?
Yes, Your Honor, no objection from the people.
Thank you. Have you received the email from Mary Ann with her email address?
I did, yes, Judge.
Anything else, Mr. Bloomers?
Nothing from the people.
Anything else, Mr. Gagnick?
No, thank you.
Thank you. I'll see you on March the 19th. You both have a wonderful afternoon.
Thank you, Judge, you as well.
Thank you. Mr. Jadala.
Yes, Judge. I was wondering if the domestic violence prosecutor is available.
Where she went.
She's come and gone, Mr. Jadala. Let's see if we can find her for you.
Okay.
I'll give her a call, Judge.
Thank you, ma'am. Mr. Lee.
Good morning, Your Honor. I'm here on our net, and we are all set to go. It's been written up. I believe he's going to plead, and as a preview, I'm going to ask for immediate sentencing. He has no criminal history.
Give me 1 second.
Certainly, Judge.
We're going to do a no contest.
Thank you. Does the complainant victim need to be heard in this matter? Two 30961 ST, State of Michigan versus William Arnett. Your appearances, please.
Good morning, Your Honor. David Lee appearing on behalf of William Arnett, who for the record consents to a Zoom hearing this morning, Judge.
Mr. Arnett, state your name for me, please, sir.
William Arnett.
Thank you, Mr. Arnett. Today was the day and time scheduled for the pretrial in this matter. The court has received from the prosecutor the people's settlement offer whereby Mr. Arnett would plead guilty to failure to stop at the scene of a personal injury, and count 2, failure to stop at scene of property damage accident would be dismissed with the terms, conditions, and sentencing to be set by the court. Was that your understanding, Mr. Lee?
It is, Your Honor.
Thank you. Mr. Arnett, raise your right hand for me, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You may put your hand down. Sir, you've had the opportunity to speak to Mr. Lee, and you understand the charges you face and the possible penalties.
Yes, Your Honor.
And after having that conversation, sir, is your understanding and agreement that you'll be tendering a plea of guilty to count 1, failure to stop at scene of a personal injury accident, and that count 2, failure to stop at scene of property damage accident would be dismissed?
Yes, Your Honor.
And sir, you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to get you to plead guilty?
No.
Are you pleading guilty, sir, because you are in fact guilty?
Yes.
Mr. Arnett, is it true that on December 8th, 2023, Michigan State Police found that you were the driver of a Ford F-150 and you knew or had reason to know that you had been involved in an accident at I-94 and I-275, property open to the travel open to travel by the public and you did fail to immediately stop your vehicle at the scene of the accident and remain there until you had complied with the requirements of statute.
Yes.
Mr. Lee, would you like to inquire further of your client?
No, Your Honor, I'm satisfied with the factual basis.
Thank you. Mr. Arnett, the court looks up your plea of guilty to count 1 and dismiss count 2. Mr. Lee, as for sentencing in this matter, I'm not sure if there was any request for restitution or if the victim in this case wanted to be heard, needed to be heard.
All I know is that Mohammed, the prosecutor, had no objection to immediate sentencing this morning, Your Honor. I mean, I'm going to do whatever the court tells me to do, you know that. But I don't see why he can't be sentenced today. There is no criminal history whatsoever.
Is there anything you want to say before fines and costs are imposed in this matter on behalf of your client, sir?
He made a mistake. He takes ownership of that mistake. He has accepted responsibility, and I'd ask for a nominal sentence in this matter, Your Honor.
Mr. Arnett, was there anything you wanted to say on your own behalf, sir?
No, Your Honor.
Thank you. Mr. Lee, the court will impose the following: a fine of $500. There's costs of $200. There's $75 mandatory crime victims fee. There's $50 mandatory state costs and $20 fund fee. The issue of restitution is not addressed and is reserved should the complainant victim in this case wish to proceed or submit requests to this court.
Your Honor, may he have a little bit of time in which to pay that money?
Absolutely. Mr. Arnett, you can do one of 3 things. You can call the court and set a payment plan. You may go onto the court's website and submit a request for a payment plan, or you may come in person and set a payment plan.
What was the, I'm sorry, what was the total on that again?
About $800.
I didn't say a total, sir. It's in about the $800 range.
Okay, yeah, I should be able to get that paid.
Okay. Is there anything else, Mr. Lee?
There is not, Your Honor. Good to see you this morning.
Good to see you too, sir. You have a wonderful day.
Thank you, Judge. Good day to you.
Good luck to you, Mr. Arnett.
Thank you. Have a good day, Your Honor.
Mr. Batar.
Judge, we're ready on Hanson.
This is 230524 SM. This is State of Michigan versus Diana Hanson. Your appearances.
Daniel Batar on behalf of Ms. Hanson, Your Honor. Ms. Hanson has just texted me, Your Honor. She's having issues logging onto Zoom. The prosecutor has made me an offer, which I would like to convey to her. So the complainant did appear today. She's in person, Judge. Can we get another pretrial at a later date? The complainant does not need to appear, and then we'll decide whether we're going to take that offer.
Thank you. How long, Mr. Batar? 1 week, 2 weeks, 3 weeks?
What days are available, Judge, in 2 weeks? March 14th? I'm sorry, that's
13th.
Thursday. Yeah. 13th. Yeah, let's do the 13th, Judge.
9:15, Judge.
9:15? Thank you.
Thank you. I'll make a notation that the complainant does not need to appear. Anything else, Mr. Batar?
Mary Ann, could you send me back into the breakout room with Mr. Mohammed, please?
Yes.
Thank you.
This is 201554 FD. This is State of Michigan versus Sierra Kimball. May I have your appearances, please?
Good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Sierra Kimball. Sierra, will you unmute your microphone and state your name for the judge, please?
Sierra Kimball.
Thank you. Today is a day and time scheduled for PCC. This file's in warrant status for some reason.
If that's the case, I would ask that the warrant be set aside and a personal bond be set for Ms. Kimball, but that would be odd at the PCC stage.
I agree with you, Ms. Pilkowitz, but I see there's a warrant stapled to the front of the file. The court is. Oh, hold on.
And Judge, I can probably clarify or attempt to.
If you feel you need to, that's fine. I was recalling the warrant. We were going to set a personal bond. What was your?
No, I mean, of course, I agree with that. This case is from 2020. It appears as though there have been several previous appearances on this matter. I was trying to figure out, as I'm recently appointed, the procedural posture of the case. I'll pause at that. If we want to deal with the warrant first, let's do that, and then we can go into the PCC.
It appears that she being Ms. Kimball was supposed to be screened for sobriety court and failed to supply the paperwork that was requested. So the warrant was issued when she failed to comply in that regard, but the court is recalling the warrant will set the bond at $5,000 personal. Ms. Kimball has appeared timely and appropriately this morning. Ms. Pilkowitz, how are we proceeding in this matter?
So I asked APA Mohammed for a bit of clarity again on the procedural posture, because this case clearly went back and forth several times in 2020 and 2021. He did not have any information. So I believe we're starting from scratch at this point. I would like the opportunity to submit a deviation letter to APA Bresnahan. If we could just adjourn the PCC a couple weeks, I will get that in.
Let's put it over, Marianne. 3 weeks puts us on March the 20th.
At 9 o'clock, Judge.
That works,
Thank
Judge.
you. March 20th at 9 a.m. That's in number 3 by Zoom with Judge Green, okay?
Sorry, it's before Judge Green?
Yes.
Okay.
Thank you. Anything else?
No, Judge. Sierra, you can sign out. I'm going to give you a call.
Thank you.
Thank you.
For Victor Stokes, I emailed the clerk a copy of the plea.
I know I have it, but I didn't see where it said no contest. That was the only holdup.
I didn't.
It's fine. Miss Medina is here and Mr. Stokes is here. I'm going to call that case. And then we have Patricia Lewis, and it says neighborhood defender. Do we know who's assigned to that case? It's you, Mr. Martin?
It is me, Judge Martin. If I could have a
If you give
breakout
me
room with Miss Lewis.
Absolutely. And then when you come out, I'll get your 3 cases called so that Mr. McKinney and Mr. Burley can get on with their days. This is 230799 SM, State of Michigan versus Victor Stokes.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
And Crystal Marie Medina, Your Honor, on behalf of Mr. Stokes. Mr. Stokes, would you please do me the favor of turning on your video and audio and stating your full name for the record, please, young man?
Trying to get me in a breakout room. The attorney is trying to get me in a breakout room. Bullets.
Hi, my name is Victor Stokes. Yes, sir.
Thank you, Mr. Stokes. Today is the day and time scheduled for the pretrial in this matter. When the case was called before, we were seeking some clarification as to the offer from the people. Mr. Mohammed has appeared in this main session and advised that this is in fact that this will be a no contest plea. Mr. Muhammad, is your representation as an officer of the court that you've reviewed this offer with the complainant and they accept the terms of the offer?
Yes.
They
Judge,
consent.
They
Sorry.
consented to the terms of the conditions. I did not discuss with them a no contest plea, but the other terms, yep.
Thank you. Mr. Stokes, raise your right hand for me, sir. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. May you put your hand down? Sir, you've had the opportunity to discuss this case with Ms. Medina. You understand the charges you face and the possible penalties.
Yes.
And after having that conversation, sir, is your understanding and agreement that you'll be tendering a no contest plea
Yes.
to count 2, assault or assault and battery upon William Roger Blay?
Yes.
And sir, you understand that if the court accepts the plea this morning, you will not have a trial of any kind.
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor.
Yes.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way or promised anything to get you to enter the no contest plea?
No.
Sir, Ms. Medina has indicated that this no contest plea is premised on your effort to limit your exposure to civil liability. For that reason, this court cannot inquire of you the way it typically does. But just so that we have a clear record, sir, is it true that you do not dispute that on October 4th, 2022 in Huron Township, that the police report indicates that you made an assault or assault and battery upon the following person, Mr. William Roger Blay?
Yes.
Satisfied, Mr. Mohammed?
Yes, Judge.
Satisfied, Ms. Medina?
Yes, Your Honor, satisfied.
Thank you. The court accepts no contest plea in this matter as to count 2, and will dismiss count 1. Mr. Mohammed, did Mr. Blay wish to have the opportunity to be heard before sentence is imposed in this matter?
Judge, in regards to sentencing, I defer to you.
No, that's not the question. No, I mean, I understand that, but if the victim wishes to make a statement.
Oh, there's no statement.
There's no statement. Any request for restitution of any kind?
No, Judge.
Thank you. Other than the anger management classes, Ms. Medina, was there anything else you wanted to say on behalf of Mr. Stokes?
Yes, Your Honor, most definitely. Mr. Stokes has been an absolute pleasure to work with. He has appeared at every court as he is ordered and required to do. He has maintained in constant contact with me. This is an incident that is alleged to have occurred back in 2021. I am not aware that there have been any other instances, contacts, issues with this young man. He maintains stable residence with his aunt. He is currently employed with McDonald's. I would ask that the court consider a term of non-reporting probation. Within that time, he would be required to complete those anger management classes and pay any fines and costs, Your Honor.
Judge, if I do recall correctly, I'm sorry to interrupt. I think the victim did want this individual to serve some jail time, but it is the people's position to defer to the court.
Thank you. Were you able to hear that, Ms. Medina?
Yes, Your Honor, and I would object to any jail sentence or ask the court not to impose any jail sentence in this case. Again, it is something that he has accepted responsibility by way of his no contest plea today. It is something that is alleged to have happened quite some time ago. He has maintained no contact, Your Honor, and I do not see the need for a jail sentence in this case if he's going to be doing anger management classes as asked to do, Your Honor.
Thank you. Mr. Stokes, is there anything you would like to say to the court?
No.
Thank you. Ms. Medina, respectfully, Mr. Mohammed, the court will not impose jail time in this matter. The court is looking at Mr. Stokes' age, looking at the fact that there is no criminal history since this incident, which was October 4th, 2022. the court will do the following. Order Mr. Stokes to complete anger management classes. Place him on 3 months of probation. The court is making that reporting probation. Ms. Medina will impose a fine of $300, cost of $200. There is $75 mandatory crime victims fee. There's $50 mandatory state cost, $20 fund fee, and $50 bench warrant fee. That's $695. Mr. Stokes, the court's probation department will be in touch with you. Sir, if you need a payment plan for the $695, please call the court's collection department. You may come in person and speak with them. The probation department will be able to assist you in getting connected to the anger management classes. You will need to complete those anger management classes and provide proof to the court. Was there anything else, Mr. Mohammed?
Nothing from the people, thank you.
Anything else, Ms. Medina?
No, Your Honor, thank you very much.
Thank you.
Apart from this, Your Honor, I just have a quick question. Do we know if Ms. Mandernack is going to be coming back? I just don't want to, I just didn't know the status on that, and I don't want to hold up the court. So if I'm not going to be able to speak with her today, maybe adjournments would be appropriate.
If I may.
Sir.
I did speak to APA Mandernich, and she advised me that she is stuck in circuit court and she isn't able to get out at this time. So potentially adjourn any cases she may have today is what I can think of. But of course, it's the judge's or the court's decision.
Absolutely, it happens. So Mr. Stokes, you're free to go. Ms. Medina, was there something else that you were waiting to see Ms. Mandernack regarding?
Yep, I believe Mr. Williams, but I will speak with him and then we'll probably just come out, request discovery and a new date, Your Honor. Let me speak with him. Thank you.
Thank you.
Thank you, Judge.
Thank you, Mr. Mohammed. What happened to Mr. Merton? Mary Ann, I'm stepping off for the briefest of seconds. Don't let the attorneys go. I'll be right back. 240095 State of Michigan versus Brendan Williams.
Crystal Marie Medina, Your Honor, on behalf of Mr. Williams. Mr. Williams, would you please state your full name for the record, sir?
Brendan Maurice Williams.
Thank you, Mr. Williams. Today is the day and time scheduled for the pretrial. Ms. Medina, how are we proceeding?
Your Honor, my understanding in speaking with APA Mohammed is that this is an APA Mandranak case. I will reach out to her and request discovery, and we would like another pretrial date, Your Honor, if at all possible.
Ms. Medina, 1 week, 2 weeks, 3 weeks?
If we could do 3 weeks, Your Honor, just I don't know how. If we could do 3 weeks.
3 weeks puts us on March the 20th at
9:15.
at 9:15. That will be on Zoom in number 3 with Judge Green. Mr. Williams, I'd like to thank you for your patience this morning, sir. Notice of that March 20th date will be mailed to you at the address you verify with court staff, okay?
I just want to make sure because I'm not going over to the Romulus address. Do you have the Taylor address on file?
Pickwick,
Yes, ma'am. Yes, Your Honor.
that's the address we have in the file, sir.
Okay.
Thank you very much.
Have a good day, Mr. Williams.
Thank you, Your Honor,
You as
and
well.
thank you, Mary Ann, for everything.
You bet.
Mr. Woodyard, are you ready?
Yes, Your Honor. Good morning. We are ready. Mr.
Good
Hinson.
morning. Mr. Henson, turn your video on, unmute yourself, sir. This is 210075 FD. This is State of Michigan versus Alan Lee Henson. Your appearances.
Judge, good morning. My name is Michael Woodyard. My P number is 64612. I'm a staff attorney at Neighborhood Defender Service of Detroit, and our office represents Mr. Hinson. He's on the call. Mr. Hinson, say good morning and say your name, sir, please.
Good morning, Alan Hinson.
Thank you, Mr. Henson. Today is the day and time scheduled for the PCC. Mr. Woodyard, how are we proceeding this morning?
Your Honor, good morning. Our office presented a mitigation or deviation packet to the prosecutor's office. And I must confess, I think I was a little bit tardy in presenting that. I've been informed that a couple of weeks are required for them to review and arrive at a determination. So if there's any way that the court can give us that time, that would be wonderful. And that's what I'm asking.
1 week, 2 weeks, 3 weeks, sir.
Whatever, let's say 3 weeks. Let's say 3.
9:15 on March 20th.
March 20th at 9:15 a.m. That's on Zoom in number 3 with Judge Green. Is there anything else, Mr. Woodyard?
Nothing on behalf of Mr. Hinson, Your Honor, just our thanks.
Thank you, Mr. Henson. Good luck to you, sir. Notice of that new date and time will be mailed to you at the address the court has on record, okay?
Thank you, Your Honor.
Thank you, sir.
Thank you, Judge. Have a great day.
You too, thank you. 240008 SM, State of Michigan versus Ali Abdelatik.
Respectfully, Your Honor, Samar Jadala, P62186, appearing on behalf of Mr. Abdulatif. Your Honor, originally we were going to set this matter for a bench trial, but I believe my client hasn't appeared. I've attempted to contact him unsuccessfully.
Thank you. Mr. Jadala, this case was scheduled at 9 o'clock. It's now 10:26 by the court's clock. The defendant has failed to appear. We'll set this matter for show cause. Was there anything else in this case, Mr. Jadala?
Nothing else on Mr. Abdulatif.
Thank you. And then there was
I have Edgar Hernandez. That's the ticket matter.
I'm sorry?
I had an Edgar Hernandez. It was a ticket that I resolved with the prosecutor. It's scheduled at 10:45.
4S 4321211 SI, State of Michigan versus Egbert Hernandez. Mr. Jadala, what was the resolution with Mr. Mohammed?
Your Honor, that was being reduced to an impeding traffic, and I have the authority to take that on my client's behalf.
Impeding, the court will impose a fine of $200. Does your client need more than 5 days to pay that amount, sir?
Your Honor, if we could have 2 weeks.
14 days. Anything else in that case, Mr. Jadala?
Nothing further on that matter, Your Honor.
Thank you. And as for your other client, sir, I don't know that Ms. Mandernack is returning. She had she's in circuit court. I do believe this is 2400077 SM, State of Michigan versus Cornell Shararu.
And Your Honor, I believe my client's here. Today was a final pretrial where all witnesses had to appear. I'm not sure if any complaining witness has appeared today.
Sir, unmute yourself and state your name for me, please.
Cornell Shararo.
Thank you, sir. Mr. Jadala, my file shows the victim as Shylon Schneider. And I do not recall having seen that name today. I'm double checking. I don't see anyone by that name in the court's main session or the court's breakout sessions. This case was scheduled at 9:45. It's now 10:28 by the court's clock.
Your Honor, at this time, we'd make a motion to dismiss the matter.
Hearing no response from the complainant, prosecution not being present, the court will dismiss the matter. The dismissal is without prejudice. Mr. Jadala, is there anything else in this matter at this time?
Nothing further. May you and your staff have a wonderful day, Judge.
Thank you. You too. Mr. Shararo, you're free to go, sir. You have a good day.
Thank you. You too.
Thank you. This is 230452 FY. This is State of Michigan versus Stephen McKinney. May I have your appearances, please?
Not hearing the prosecutor, I'll go ahead. Good morning, Judge Martin. Good morning to your staff, Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. Stephen McKinney, who appears by Zoom. Mr. McKinney, can you turn your camera back on and state your full name for the court?
Stephen McKinney.
Thank you, Mr. McKinney. Today is the day and time scheduled for the PCC. Mr. Martin, how are we proceeding?
Your Honor, there was a discovery order signed in this case with a discovery deadline of yesterday to provide digital evidence. As of now, I've received no digital evidence. I've received only a police report. I do not believe that enough evidence has been collected in this case, and I would be asking for dismissal.
Mr. Martin, respectfully, I would like the prosecutors the prosecutor to be present for such a motion. Let me see if we can get Mr. Mohammed out.
I would too. Thank you.
Mr. Mohammed, sorry to interrupt your breakout session, but this is Mr. Martin and Mr. Stephen McKinney, 230452. This case was scheduled at 9 a.m. 9:15. Mr. Martin has made a motion to dismiss for failure to receive discovery. Do you have any response, sir?
Yes, Judge. Can I get just a brief moment to pull up the case?
Yes, sir.
So, Judge, yes, I would object to any dismissal of this case due to the lack of any digital evidence. And the reason is because it doesn't exist. So the people can't turn over what they don't have. I emailed the officer in charge, Wickham, And, I asked him if there was any body cam or anything that exists in regards to digital evidence. And he indicated to me that it does not. And then I further wanted to confirm it. My exact response was, okay, I will case note that there is no body-worn camera or digital evidence that exists for this case, only the reports we have on file. Is that correct? His response was yes. So due to that response, Judge, the people are objecting to the dismissal of this case because there's no digital to give over.
Mr. Martin?
I would continue to make my motion, but of course, if the court is inclined to just set this for preliminary exam, I understand and will be prepared.
The request to the request to dismiss this case is denied. That exam date will be
April 3rd at 2 o'clock, Judge.
Very well, thank you.
Thank you. Anything else, Mr. Mohammed?
Nothing from the people, thank you.
Anything else, Mr. Martin?
Nothing from defense about Mr. McKinney.
Thank you. Mr. McKinney, I will see you here in courtroom number 1 on April the 3rd at 2 p.m., sir. Notice will be mailed to you at the address that we have on file, okay?
Okay, thank you, Judge.
Thank you.
Thank you.
This is 200322 FY, State of Michigan versus William Burley. Your appearances, please.
Good morning again, Judge. This is Carrie Martin, P 84592, Neighborhood Defender Service, appearing on behalf of Mr. William Burley III. Mr. Burley, please unmute your device, turn on your camera, state your name for the court. Mr. Burley, can you hear us? Your case is being called. Oh, here he is.
Yes.
State your name, sir.
William Burley.
Thank you, Mr. Martin. Today is the day and time scheduled for the PCC. How are we proceeding?
Your Honor, in this case, I am also making a motion for dismissal based on a discovery violation. This is a incident dating to 2014, and the charge dates to 2020. And I submitted a discovery order, which was signed by Judge Green, and with only a police report. This is a case where the report indicates physical evidence
Mr.
was
Martin?
seized.
I'm sorry, Mr. Martin, give me one moment.
Thank you.
Mr. Mohammed is not in this session, so let's pass this matter momentarily.
Very well.
Was that all that you had, Mr. Martin?
That there is also
Oh, you had Ms. Lewis.
Patricia Lewis. There's no motion in that case, so
She's still in the breakout room, sir. Give me a moment. Let me clear some other things out. We'll get Ms. Lewis out.
All right, thank you.
Thank you. Mr. Powers, 24L022868. State of Michigan versus
Waste Management. Good morning, Your Honor. Sean Powers, P42752, on behalf of Defendant Waste Management.
Thank you, Mr. Powers. Have you had a chance to speak to Mr. Mohammed?
I have, Your Honor. We've arrived at an agreement to resolve the matter for a fine of $2,305.
Court will accept your plea of responsible on behalf of your client to the overweight and impose a fine of $2,305. Does your client need more than 5 days to pay this amount, sir?
Is 14 days acceptable, Your Honor?
14 days is acceptable. Anything else, Mr. Powers?
No, Your Honor. Thank you very much.
Thank you, sir.
Okay,
Have a good day. Mr. Kelly, is Ms. Evans with you?
She is, Your Honor.
Thank you, sir. This is 240081 SM. This is State of Michigan versus Lucille Evans. May I have your appearances, please?
Yes, Attorney Michael Kelly, P77187, on behalf of Ms. Evans, who's present, seated to my left. State your name, please.
Lucille Evans.
Thank you, Ms. Evans. Today is the day and time scheduled for the pretrial. Mr. Kelly, how are we proceeding?
Yes, Your Honor, at this time, I am going to be requesting an adjournment I have received initial paper discovery from the prosecutor, but I do in fact still need the audio video camera from this incident.
How long of an adjournment, Mr. Kelly? 1 week, 2 weeks, 3 weeks?
3 weeks should be fine.
March 20th at 9:30.
March 20th, 2024 at 9:30 a.m.
I need a
That will
different
be-
date on that. I'm gonna be traveling on the 20th.
You need a different, okay, a week earlier, March the 13th?
Yeah, that works.
Same time, 9:30.
At 9:30, that will be with Judge Oakley
Okay,
in
thank you.
person in courtroom number 2.
Okay, thank you.
Anything else?
Nothing further.
Have a good day, Mr. Kelly. Good luck to you, Ms. Williams, Ms. Evans.
Thank you.
Thank you. This is 240075 FD. This is State of Michigan versus Patricia Lewis. May I have your appearances? Nope. Mr. Johnson, this is 210672 FY, State of Michigan versus Jamellen Thompson.
Good morning, Your Honor. May it please the Honorable Court, Vassal Johnson II, P72130, on behalf of Ms. Thompson. She is present on Zoom and consists of being present on Zoom. State your name, ma'am.
Ms. Johnson, Ms. Thompson?
Yes, ma'am, I'm here.
State your name, ma'am.
Jamellen Thompson.
Thank you. Today's the day and time scheduled for the PCC. Mr. Johnson, how are we proceeding?
Yes, Your Honor. Mr. Mohammed just sent over the digital link yesterday. Has to be downloaded. I have to view it, and Ms. Thompson has to view it. And I also like to talk to Mr. Mohammed about resolution, which we discussed. So I would just ask for an adjournment of the PCC. If we can have the 20th, that'd be great.
9:15.
Perfect.
March 20th at 9:15 a.m. Ms. Thompson, that will be on Zoom in number 3 with Judge Green. Notice will be mailed to you at the address on file with the court. Anything else, Mr. Johnson?
No, Your Honor. Thank you.
Thank you. Ms.
Have a good
Thompson, good luck to you. You're free to go. You have a good day.
You too.
Thank you. Ms. Sazanova? Ma'am, who is your client, please?
Good morning, Your Honor. Yes, I am here on behalf of, last name is Mykhaylak, Mykhaylyak. Boris is the first name.
3S431308, State of Michigan versus Boris Mykhaylak. Ma'am, you've had the opportunity to speak to Mr. Mohammed.
Yes, I have, and we're going to be asking for a 1-week adjournment so we can work on a possible resolution of this matter. And this is on Mr. Mohammed's initiative.
March 6th at
9 o'clock.
March 6th.
March 6th at 9 o'clock.
Okay, that works, Your Honor.
Okay, that's with Judge Oakley in number 2. Have a good day, ma'am. Thank you.
Judge Oakley, is that going to be the same Zoom number?
No, ma'am, it's a different Zoom ID. If you need it, I can give it to you right now.
Please, if you don't mind.
491-975-6074.
Repeat, it's 491-975-6074.
Yes, ma'am.
Thank you kindly. I appreciate it.
Thank you. Have a good day.
As well. Thank you. Bye-bye.
Thank you. This is 230953FY. This is State of Michigan versus Mykesha Malcor. Mr. Forrest. Sir, your client has not appeared.
Judge, I just spoke to her. She's not on. All right, let me,
It might be her with no audio. Sit tight, sir. Ms. Medina, were you ready with something else?
Ready on Mr. Taylor. He is having some issues with the Zoom, but I think Mr. Taylor.
This is 23.
Yep, I'm here.
230814 SD, State of Michigan versus Gary Taylor. State your name for me, sir.
Gary Taylor.
Thank you. Ms. Medina, how are we proceeding with this pretrial?
Your Honor, I did have the opportunity to speak with APA Mohammed. At this time, the offer is for operating while impaired. He is going to be sending me discovery on the matter, and we're seeking adjournment, if possible, to that March 20th date, just for him to consider that offer and for us to review discovery.
At 9:45.
Mr. Taylor, your case is being adjourned to March the 20th, 2024 at 9:45 a.m. That will be by Zoom in number 3 with Judge Green. Sir, if you have some technical issues, there is a Zoom room available here at the courthouse. Other than that, the other issue is that there is a request for fingerprints. Mr. Taylor, you need to report to the Van Buren Township Department of Public Safety before your next appearance date and have your fingerprints taken. Anything else in this case, Ms. Medina?
No, Your Honor. Thank you very much.
Thank you. Mr.
Sounds
Taylor,
good.
you're free to go, sir. You have a good day.
Thank you so much, guys. Have a good day.
You
See you
too.
then.
Thank you, Mr. Taylor. Take care. And Your Honor, if I could just let APA Manderneck know, I'll be waiting in her breakout room for whenever she's ready.
Thank you very much for letting me know.
Absolutely.
Right now? Yeah. What? They all work out here. Don't turn this one out. Take up on the left side. You and not anymore.
To the person with your phone pointed towards the ceiling, what is your name, please?
Hello?
Yes, you. Your name, please.
Marquise Baker.
No, sir. Ma'am with the pink shirt on. What happened to Mr. Merton? This is 190327 SM State of Michigan versus Maisha McGraw. May I have your appearances, please?
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of and with Ms. McGraw. Ms. McGraw, could you tell the judge your name for the record, please?
Maisha McGraw.
Thank you, ma'am. Your Honor, Ms. McGraw and I need to have a discussion. Can I get into a breakout room with her, please?
Absolutely.
Thank you.
Mr. Alkazi, what are you here for, sir?
Yes, Your Honor. I just spoke with prosecutor attorney, Mr. Mohammed. My client, he failed to show up today and the last time. So I don't know what to say.
Who is my question is, Kames, thank you.
Kamis, yeah, Abdullah Kamis.
Yep. 230541 FY, State of Michigan versus Abdul Kames.
Good morning, Your Honor. Haitham Al-Qudsi, P number 68565 on behalf of the defendant. He's not with us via Zoom.
Thank you. This case was scheduled at 10 a.m. It's now 10:48 a.m. by this court's clock, sir. Your client had his appearance waived when he appeared in this courtroom on January 17th, and is your indication now that he failed to appear on February 7th with Judge Green?
Yes.
Defendant having failed to appear, this matter will be set for show cause. Is there anything else, sir?
No, Your Honor. So you send me a date for the show cause?
Yes, they will.
Thank you very much, Your Honor. Have a nice day.
Have a good day.
Thank you, you too.
Two 30953 FY, State of Michigan versus Melchor. Your appearances.
Good morning, Your Honor. Matthew Forrest, P73168, appearing on behalf of Keisha Melchor, who's present via Zoom.
Unmute yourself and state your name, please, ma'am.
Keisha Melchor.
Thank you. Today is a day and time scheduled for the PCC in this matter. Mr. Forrest, how are we proceeding?
Your Honor, the prosecutor has made an offer to Ms. Melchor to reduce the retail fraud first degree to the misdemeanor retail fraud second degree. I have discussed this offer with Ms. Melchor, and to my understanding, she wishes to accept it today. I believe the plea form was sent into the court yesterday.
The plea form is in the file, but Mr. Forrest, before I am able to accept that plea from your client, I need to advise you that I'm married to an elected official in Van Buren Township. I make that disclosure as Van Buren Township is the police agency involved in this matter. My husband is not involved in the day-to-day operations of the public safety department. He doesn't know anything about this case. He doesn't even know that it's scheduled. That being the case, sir, would you like a moment to speak to your client, or are you prepared to proceed with the plea?
I'm prepared to proceed with the plea unless Ms. Melchor needs to speak to me. Ms. Melchor?
Ms. Melchor?
Yes.
Are you prepared to proceed with the plea?
Yes, ma'am.
Ms. Melchor, is there a reason why you weren't here at 9 o'clock as scheduled?
My phone was turned off. I had to buy the services. I tried to pay it yesterday when the bill was due, but I couldn't, so I got someone to pay it this morning, and they did, so I could get on court.
Thank you, ma'am. Would you raise your right hand for me, please?
Yes,
Do you
ma'am.
swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am. You may put your hand down.
Thank you.
Ma'am, you
And I
understand that if the
apologize
court
for the-
accepts your plea this morning, you will not have a trial of any kind. Ma'am?
Yes.
You understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes, ma'am.
And ma'am, are you entering this plea freely and voluntarily?
Yes, ma'am.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No, ma'am.
Are you pleading guilty because you are in fact guilty?
Yes, ma'am.
Ma'am, is it true that on January 29, 2023 in Van Buren Township, you entered the Meyer store that was open to the public and you did steal property from that store that was offered to sell for the public?
Yes, ma'am.
Mr. Forrest, would you like to inquire further of your client?
Just that the value of that property was over $200. Is that correct?
Yes.
Thank you, Judge.
Thank you. Ms. Melcher, the court will accept your plea of guilty to retail fraud, second degree. Impose a fine of $500, cost of $100. There's $75 mandatory crime victims fee, $50 mandatory state costs, and $20 fund fee. There is a request for restitution to Meyer in the amount of $324, 40 hours of community service.
Judge, if I may, I did have a discussion with the prosecutor yesterday with regards to this plea, and he indicated to me he had no objection to the 40 hours of community service to cover any court costs that it could, if the court is willing to do that.
The court is not willing to do that, Mr. Forrest. The court has had the opportunity to review Ms. Belcher's criminal history along with what has occurred in the matter scheduled for the court today. The court has some concerns about Ms. Melcher's repeated issues, I guess I would say. But if it's your understanding that it was fines and costs or community service, the court is willing to reduce the number of hours of community service.
Thank you, Judge.
Thank you. Ms. Melcher, the court will reduce that community service to 18 hours of community service to be completed within the next 6 months. Ma'am, other than that, I would ask that you contact the court's collection department to establish a payment plan for the fines and costs imposed today, along with the other monies that you owe the court. And ma'am, as you complete your community service hours, those 18 hours over these next 6 months, you need to submit documentation to the court's probation department that demonstrates the completion of those hours. If you do not have a nonprofit that you have a relationship with where you're able to complete those hours, you may reach out to the court's probation department. They have a list of agencies that would be happy to assign hours to you. Mr. Forrest, is there anything else in this case this morning?
No, Your Honor. Thank you.
Thank you. Good luck to you, Ms. Malcoy. You're free to disconnect. You have a good day.
Thank you. You have a blessed one.
Thank you. 190327 SM State of Michigan versus McGraw.
Ready, Your Honor. Once again, Your Honor, Jeffrey Bowder, appearing on behalf of and with Mr. McGraw. Ms. McGraw, could you tell the judge once again your name for the record, please?
Maisha McGraw.
Thank you, ma'am. Your Honor, today's the date time set for pretrial. We do have a plea agreement in this matter in which Ms. McGraw would be pleading no contest to the charge, to one charge of larceny with a dismissal of the other. The no contest plea, Your Honor, this is a 2019 case, little problem with memory. But she's not going to fight the charges.
I'm sorry, you said she's not what, sir?
She's not going to fight the charges, Your Honor.
Oh, thank you. Ms. McGraw, would you raise your right hand for me, please, ma'am? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may put your hand down. You had the opportunity to discuss this case this morning with Mr. Bowder. As you understand the charges you face and the possible penalties.
Yes.
And ma'am, after having that conversation, is your understanding and agreement that you'll be tendering a plea of no contest to larceny, $200 to $1,000, and that the stolen property receiving and concealing would be dismissed?
Yes.
And ma'am, you understand that if the court accepts your plea this morning, you will not have a trial of any kind?
Oh, yes, ma'am.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes.
And ma'am, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead no contest?
No, ma'am.
Ma'am, because this is a no contest, Mr. Bowditch has made the indication that you do not recall, so just so that we have a clear record, the complaint filed in this matter indicates that on August 11, 2018, at Detroit Metro Airport, which is located in the city of Romulus, that you did commit the act of larceny by stealing a Sony PlayStation 4 that belonged to Kenneth Williams. The value of the property stolen was at least $200 or more, but less than $1,000. This is contrary to MCL 750.3564A.
Yes.
Your Honor, I believe there is restitution of $155.
Thank you, Mr. Bowditch. Other than that, Mr. Bowditch, was there anything you wanted to say before fines and costs were imposed in this matter?
Nothing, Your Honor.
Ms. McGraw, was there anything you wanted to say to the court?
No, no, ma'am.
Thank you. Ma'am, the court has accepted the no contest plea to count 1 and dismiss count 2. The court will impose the following: a fine of $200. There's cost of $100. There's $75 mandatory crime victims fee. There's $50 mandatory state cost, $20 fund fee, $50 bench warrant fee, and the $150 of restitution. That's $645. Do you need more than 5 days to pay that amount?
Can I get 14, please?
Absolutely, 14 days to pay. Anything else, Mr. Bowditch?
Nothing, Your Honor. Thank you.
Thank you. Ms. McGraw, that concludes this matter. You're free to go. You have a good day. Good luck to you.
All right. Thank you.
Mr.
I
McGraw.
appreciate it. Thank you.
Your Honor, with your permission, I'm
This
going to
is-
leave.
Absolutely, Mr. Bowditch. Thank you for your help this morning.
Yes, ma'am.
This is 240011 SM State of Michigan versus DeMarco Willingham. Your appearances, please.
Good morning, Your Honor. Patricia Mandernack for the people, P84088.
Charlene. Mr. Willingham, would you
Yes.
state your name for me, please, sir?
Marco Willingham.
Thank you. Today was the day and time scheduled for the pretrial. Ms. Kirkland, how are we proceeding?
Good morning, Your Honor. We're requesting one last adjournment, a 2-week adjournment. We did submit a deviation. We received a response to that deviation today. Me and Mr. Willingham did get a chance to speak a little bit about that, but after that conversation, we're going to need to speak a little bit more about how he wants to proceed. So we're requesting a 2-week adjournment.
2 weeks puts us on March the 13th at
9:45.
At 9:45, that will be in number 2, in person with Judge Oakley. Ms. Kirkland, is there anything else?
No, Your Honor. Thank you.
Thank you. Mr. Willingham, you're free to go, sir. Notice of that new date and time will be mailed to you at the address we have on record. Good luck.
Thank you.
Thank you, Your Honor.
This is three S 4037721 SI. This is State of Michigan versus Sammy Bryant. Sir, state your name for me, please.
Sammy Bryant.
Mr. Bryant, today was the day and time scheduled for your formal hearing. The court has just received a notice that this case needs to be adjourned.
Okay.
Mary Ann,
Yes. April 3rd at 11 o'clock.
Mr. Bryant, April 3rd at 11 o'clock, notice will be mailed to you at the address we have on file.
What does that mean?
What does which part mean, sir?
Adjourn. I went to the first
I'm sorry?
Zoom meeting. I went to the first Zoom meeting. The police officer didn't show up. And this is the second one.
Mr. Bryant, I can't hear you, sir. What are you saying?
So I went to a Zoom meeting before this one. The officer did not show up. And I don't know what's happening today.
I can't make out what you're saying, sir.
I went to one Zoom meeting and the officer didn't show up. Are the officer not showing up today?
Mr. Bryant, what I received is information from other court staff that there's been an incident and that the officer is unable to appear, that someone else in the courthouse spoke to you and that you were unable to appear by Zoom and you were appearing by audio only. That being the case, the court is finding good cause to adjourn this matter and the court is adjourning it over till April the 3rd at 11 a.m.
April 3rd. That'd be when my plant
Notice,
will be shut
sir,
down.
notice of that new date and time will be mailed to you. But that concludes this matter. You're free to go. You have a good day. Good luck to you.
All right, thank you.
Thank you. Mr. Baker.
I'm the attorney on that case, Your Honor.
Yes, ma'am.
I see Mr. Baker is in here. We'll be asking for an adjournment.
240065 FY, State of Michigan versus Marquise Baker. Your appearances. Ma'am.
Sorry. Okay, I think that's just.
Court?
I am not.
I need your appearance, please,
yes.
And then I'll have Mr. Baker state his name for the record.
Yes. Alana Altler, P number 87128 on behalf of Mr. Marquise Baker. Mr. Baker, could you please state your first and last name?
Marquise Baker.
Thank you, Mr. Baker. Today is the day and time scheduled for the PCC. Ms. Altler, you've indicated that you'd be seeking an adjournment.
That's correct, Judge. We are working with the job court program to see if Mr. Baker can qualify. So we are just seeking a brief adjournment to see if he does get admitted.
1 week, 2 weeks, or 3 weeks?
3 weeks would probably be preferable just to ensure that we have enough time.
March 20th at
10 o'clock.
At 10 a.m. That will be on Zoom. In number 3 with Judge Green. Ms. Altler, is there anything else at this time?
Nothing further, Judge. Thank you.
Thank you. Mr. Baker, thank you for your patience today, sir. You have a good day.
You too.
Heather, are you leaving us?
Yes, Judge. Thank you.
Thank you for your help this morning, ma'am.
Yep. Thank you.
What happened to Mr. Merton?
Judge, I just left him a message. I don't know.
Mr. Burley? Two 30796 FD, State of Michigan versus Levon Vinston. This case was scheduled at 8:45 a.m. It is now 11:06 a.m. by this court's clock. The court has not seen the defendant today, and Mr. Martin, who had been present, is no longer present. Come on.
Miss Lewis,
Yes, ma'am.
you spoke with Mr. Martin, right?
I sure did. Yeah, he said we were gonna come back in front of the judge and I believe ask for an adjournment.
Okay.
Or-
All right, thank you.
You're welcome.
Bench warrant shall issue 5,000, 10%. Marianne, it was 2300541 FY State of Michigan versus Abdul Kames, Khamees. If you pull that one to the side, that was a defendant having failed to appear, it should be bench warrant.
You got it.
5,000, 10%. This is 4S4316952 SM, State of Michigan versus Ton Transport. This case was scheduled at 9 a.m. for arraignment pretrial. That's what it was, a misdemeanor. Defendant having failed to appear. That's the show cause. What happened to? Two four L565963OT. This is Wayne County Sheriff versus Todd Zimmer. This case was scheduled for arraignment pretrial at 9:15 a.m. It's now 11:11 a.m. by this court's clock. Defendant having failed to appear. This matter will be set for show cause. Two, 3 RP 06078 SM, State of Michigan versus Kevin Kelly. Kevin Kelly. This case was scheduled at 9:30 a.m. It's now 11:11 a.m. by the court's clock.
Yeah, you know, that's on these people. Thank you.
Case will be set for show cause. Ms. Lewis, 240075 FD, State of Michigan versus Patricia Lewis. Ma'am, I know you spoke to Mr. Martin. He just came back.
Yes, ma'am.
Wonderful timing.
Awesome.
Mr. Martin, for Ms. Lewis, your appearance, sir.
Good morning, Judge Martin. Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Ms. Patricia Lewis, who appears by Zoom. Ms. Lewis, can you state your full name?
Patricia Kathleen Lewis.
Thank you, Ms. Lewis. Today was the day and time, or is the day and time scheduled for the arraignment in PCC. There's a warrant on this file. The court is recalling the warrant. Mr. Martin, how are we proceeding?
Yes, and we would waive the formal reading of that warrant, stand mute to the charge. And regarding Ms. Lewis's bond, I would ask that the court set a nominal cash bond in this case, something along the lines of $1,000, 10%.
Mr. Martin, the recommendation from Belleville Police Department is that Ms. Lewis's bond be set at $50,000, 10%, because she is currently on probation because of the seriousness of the offense, the multiple prior convictions for the same offense. They're asking that if she is released, additionally, that she be placed on alcohol tether monitoring and or drug and alcohol counseling. What say you to that recommendation, sir?
Well, Your Honor, I believe that recommendation was from around the time of the incident, which predated Ms. Lewis being sentenced to Michigan Department of Corrections on that aforementioned probation. So given that she's now an MDOC and any release would be under conditions of parole as set by MDOC, I don't believe that Your Honor needs to impose all of that. It would just be surplus on top of her parole conditions. So I believe that the nominal cash bond with no tether and no other conditions is sufficient given the circumstances.
1,000, 10%.
Thank you.
As
Thank
for
you,
the
Your Honor.
PCC, Mr. Martin, you're welcome, Ms. Lewis.
And Your Honor, I would be asking for another PCC a few weeks out in this case. I do need time to collect digital discovery and also to potentially submit this to or assess this for a misdemeanor reduction request.
1 week, 2 weeks, or 3 weeks, Mr. Martin?
3 weeks preferable. Thank you.
March 20th at
9:45.
at 9:45. That will be by Zoom in number 3 with Judge Green.
Thank you.
Is there anything else, Mr. Martin?
Nothing for Ms. Lewis.
Thank you. Ms. Lewis, you're free to go, ma'am. You have a good day. Good luck to you.
Thank you, Your Honor. You have a blessed day.
Thank you. This is a recall of 200322 FY State of Michigan versus Burley.
And good morning again, Judge Martin, Neighborhood Defender Service, Carrie Martin, P84592, appearing on behalf of Mr. William Burley, who still appears by Zoom. Mr. Burley, state your name again.
William Burley.
Oh, Mr. Muhammad.
Yes, I believe I was in the midst of a discovery motion. Yes.
Mr. Muhammad, in the matter of William Burley III, Mr. Martin had been in the midst of making a motion to dismiss this matter. I put it to the side so that you would have the opportunity to respond to it. Mr. Martin, your motion.
Yes, Your Honor. This case against Mr. Burley dates back to 2014. The report that I've received, which is the only discovery I've received, mentions physical evidence that was seized from Mr. Burley's car. It was a traffic stop with a police encounter. And yet I've received no digital discovery. I received no physical evidence. I also, in an order that was signed by Judge Green, asked that all such evidence be provided by yesterday and that I be given the opportunity to inspect the physical evidence by yesterday. And there's been no follow-up about that. Conversations with APA Mohammed sounds like he's been trying to reach out to the OIC to get clarity on this, and there's been no response as to whether or not this discovery still exists. So, and I'll also note that the delay here was not Mr. Burley's fault. It was in fact nearly 6 years between the incident date and the filing of this case for reasons that, you know, to be honest, confound me. This case was not filed in court until the year 2020. And certainly if there was loss of evidence during that 6-year period, that would not be Mr. Burley's fault. So I am asking for this case to be dismissed today. And if Your Honor is not inclined to dismiss it, I would ask that an evidentiary hearing or a discovery hearing be set to really understand where this discovery might be, if it's lost, what the explanation might be, etc.
Mr. Mohammed.
Judge, I did send three requests to the OIC for digital discovery. I have not had any responses. Mr. Martin is correct that it was a case from 2014, which I think explains why there's no digital evidence. I think, again, this is an assumption and I'm speculating, but I'm assuming that they just didn't have digital discovery back on that day. Mr. Martin identified that in the discovery packet, it talks about the officers recovering evidence. There's nothing in the records that indicate that there was any digital evidence, from my understanding, based off of his representation. And so therefore we would object to dismissing this case. As to it being issued 6 years later, again, I don't have any information onto why that occurred. That just comes from other people in the office, but I'm sure there's good reason for it, and there's nothing that shows any bad faith by the people or any officers. So we would just object as to the dismissal of this case.
And Your Honor, if I just briefly, I'm not even alleging bad faith per se in this delay, but it is a delay of prosecution that is not at all attributable to Mr. Burley and puts him in significantly worse footing when it comes to this case, if this case were to proceed, not just because of loss of physical and possible digital evidence, but even because of loss of memory, of witnesses, of himself. That amount of delay just makes it harder to present a defense, full stop.
Mr. Martin, I'm just looking for a copy of the discovery order. You referenced it, and give me a moment.
Yes, and if for any reason it's not in the file, I could email you a copy or email Marianne a copy shortly.
I don't know that Mr. Mohammed, you're not disputing that there was in fact an order for discovery signed that required the prosecutor's office to tender discovery to Mr. Martin by yesterday, February 27th, are you?
I believe there was a discovery order in place. If you give me just a brief moment, I can just confirm that because I think I may have forwarded it to the officer in charge. I'll be very brief. Yes, I did attach in an email a copy of the discovery order, trying to give the officer in charge notice in my third request. So there was a discovery order. Let me just confirm that it was signed by a judge. So the document that I have does not appear to have the signature of a judge. It's totally blank. But there was a proposed order by Mr. Martin, and it indicates that it should include any, it's not limited to, but it's video and photographic evidence, and shall provide defense counsel with an opportunity to view and inspect physical evidence.
And Your Honor, I definitely did submit that proposed discovery order. Upon further review, I may not have received a signed copy of that back. So I did not intend to make a misrepresentation there. It may have just been I believed wrongly that we had received the signed copy back. So if it's not in your file, then I'm no longer going to assert that there was a filed a signed copy with a discovery, with Judge Green's signature. I would simply still ask for dismissal based on the lack of discovery, or if Your Honor is unwilling to dismiss at this stage, I would ask that Your Honor sign that proposed order, and I can send you a copy of that shortly with a deadline within the next week.
Mr. Martin, respectfully, the court will sign the discovery order that you present to the court. I have gone through every piece of paper in this file. There is no discovery order. I've looked on the ROA. There is no indication that a discovery order was received by any of the judicial secretaries or processed. That being the case, the court will deny your current motion to dismiss for lack of this compliance with an order of discovery and adjourn this matter over. If you believe that a week will be sufficient time, the court will adjourn it to next week's docket, March the 6th.
Is that still with Your Honor, or is that with Judge Oakley?
That's with Judge Oakley, sir.
Yeah, I only asked because I expect to be in a trial, jury trial in Frank Murphy on the 6th. That should be the second day. So I'd be unable to appear in person with Judge Oakley on that day.
March the 20th?
We can do this on the 20th. If Your Honor is still inclined to sign an order with a sooner deadline than that, so that the sooner than the 20th.
I'll sign an order that says 2 weeks from today, just because I want to give time to get where it needs to be and sign it. March the 20th at what time, Marianne?
10 o'clock.
10 a.m. with Judge Green in number 3, but I will sign the discovery order today or tomorrow if you get it over, Mr. Martin.
Thank you. I will send it over to you today.
Mr. Martin.
Sorry, I didn't catch that.
I said, just please copy me into the email.
I will.
I have it. Thank you.
Mr. Burley, you're free to go, sir. You have a good day. Thank you.
All right, you too.
Why are you all coming up that way? You scared the...
All right. Thank you, everyone. Thank you, Judge
Thank
Martin.
you.
I'll see you later.
Marianne, holy frioli.
Judge.
Wait. I was about to gather my belongings. But we have an 11:30 exam. So I won't go far. I guess we will take the briefest recesses. Or maybe not. Mr. Martin is back.
Hi. I'm sorry. I meant to ask a question. Did Washtenaw County Jail ever zoom in about Mr. LaJohn Vinston?
No.
Okay. Yeah, he was set for a PCC today, and it did look like in the Register of Actions that a notice had been sent to Washtenaw. I wonder if that should just be reset for another PCC.
Thank you, Mr. Martin, for zooming in, because I called that case and his lack of appearance. 230796 FD, State of Michigan versus LaJohn Vinston.
Good morning, Judge Martin. Carrie Martin.
Marianne, would one week give us enough, give enough time to get notice to Washington?
Yes.
March the 6th? Oh, no, you just said you're in jury trial, right?
Well, if Washington is just zooming him in, and if Judge Oakley would permit my Zoom appearance since he'll be on Zoom, then I could probably handle it before what would be day 2 of our trial.
I'll
So
say 8:30 on the register of actions, number
Great.
2 by Zoom, 8:30. Thank you.
Thank you so much. I'll see you later.
Yes, sir. Hey, how are you? Have I seen you today? Have I seen you today?
Yeah, I've been in here like 3 times. Every time a person comes in.
Oh, yeah. I saw you, but I haven't talked to you. Top of the morning.
Yes, our 11:30 is gonna be a hold, so.
Everybody here ready?
Yes.
11:30 is holding.
Yes.
It would be nice if they were, are they gonna start on time too?
He says everyone's here.
Wow, cool.
Here, like walking in right now?
No, they're on the hallway. She hasn't talked to Muhammad yet, but other than that, we're ready.
It's 11:28. We'll start at 11:35. So you would let them know,
Okay.
please and thank you.
Yeah, I've been for like the last 5 months. Yeah. Do compassionate, do your thing, but don't ever, risk moral action.
Don't plan to. I know, but that's not saying much. You may be seated. Yeah. This is 230845 FY. This is State of Michigan versus Bobby Coleman. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Your Honor. Sarah Khan on behalf of Mr. Coleman, P86948. Mr. Coleman, would you please state your name for the record?
Morning, Your Honor.
Good morning, Mr. Coleman. Today is the day and time scheduled for the exam in this case. There is one count of carrying a concealed weapon. Are the people ready to proceed?
Judge, the people are unable to move forward. The officers in this case have failed to appear. It was just brought to my attention by the officer in charge, Dale Harrison, that they will not be appearing today, and so we are unable to move forward.
At this time, we would move to dismiss.
Ms. Khan, I heard your motion. Why was this case adjourned from January 10th to today? Do you recall?
Yes, I ended up being in trial during that period of that 3 days in 36 District Court, and I was brought onto the trial after our court date was scheduled.
Thank you. Any response to the motion to dismiss?
Judge, this would be the people's first motion to request an adjournment, so I would request an adjournment. So there may have been some technical difficulties with them receiving their subpoenas. I don't think there's anything that would show bad faith on the police officer's behalf. I think due to this being the people's first request, we can adjourn this.
What technical difficulty, Mr. Mohammed?
So my understanding, they may have not received their subpoenas. It was sent from our office, but I think maybe internally they may have had some system glitches. I don't know exactly. The officer in charge is gonna do some further investigation when he goes back.
Well, Mr. Mohammed, respectfully, this case was scheduled for today. Ms. Khan is here. Defense attorney, I'm sorry, Mr. Coleman is here. The Van Buren Township Department of Public Safety did not confirm his officer's attendance prior to this case being called. That's an issue that they can address internally. The court will grant the motion to dismiss. Is there anything else, Mr. Mohammed?
Nothing from the people.
Anything else on behalf of Mr. Coleman?
No, Your Honor, thank you.
Thank you. That dismissal, of course, is without prejudice. Have a good day, Mr. Coleman. You're free to go. Good luck to you. There were pleas in those two files.
Dismissal form?
Yeah, I would wait. You could get it online.
Oh, okay.
Yeah, just go online and look up the,
The ROA.
yep, ROA,
Okay,
and you can get right on it.
okay, perfect. Thank you very much. Yes.
You want me to give it this card, I can, let me know. All right, well, give you a heads up, so that way you.
I appreciate it. our paperwork and we'll get you guys out here. Thank you for putting this. No, I can't move. Well, we're gonna see. I'm on the right. Thank you. Okay, show up nonsense and maybe get a little bit. Go.
This is 240019 FY, State of Michigan versus Janet Crossley.
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
And good morning or afternoon, Your Honor. Tim Sean, Neighborhood Defender Services, P59167, and it's my privilege to represent Ms. Crossley, who stands to my right. Your Honor, as of this morning, we've had a lovely conversation regarding the nature of a preliminary examination in that the people would need to establish only by probable cause the crime has been committed. She may be involved in that matter. After that discussion, she wishes to freely and voluntarily waive that right, understanding to be bound over the circuit court on the charge on the complaint and the warrant.
Thank you. Ma'am, state your name for me, please.
Janet Crossley.
Ms. Crossley, raise your right hand. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Were you able to hear Ms. Maishan just now?
Yes.
And ma'am, you understand that you have an absolute right to have this preliminary examination.
Yes.
And after consultation with your attorney, you wish to waive your right to have that examination.
Yes.
And ma'am, are you doing so freely and voluntarily?
Yes.
Have you been threatened in any way or promised anything to waive the exam?
No.
Ma'am, you understand that once this exam is waived, the next step in these proceedings is that you will be bound over on the charges against you, and an arraignment on the information will happen at the Frank Murphy Hall of Justice.
Yes.
I have passed the file down. Ms. Maishan will sign, you will sign. Mr. Mohammed, do you have any objection to
No
the
objection.
waiver? Thank you. The court will find that the waiver of the exam has been freely and voluntarily given. Once Mr. Mohammed signs that the prosecutor's office does not object to the waiver, the court will sign the same. And then Ms. Crossley, as indicated previously, your next appearance date will be at the Frank Murphy Hall of Justice. That will be on Wednesday, March the 13th at 9 a.m. Thank you, sir. The file is back. It has been signed by all necessary parties. Arraignment on the information date, March 13th at 9 a.m. Ma'am, your previously entered bond with any of its conditions will continue.
We would like to address that.
Oh, before we say that, Ms. Maishan.
Thank you so much, Judge. I cannot believe I have to indicate to this court what I have. The complaining witness in this case is my client's sister. She is here today. The house where this took place is my client's house, where the complaining witness is now taking up residency without rent or anything. And the court has required my client to move out of her own home. She has, in fact, taken out, I'm not sure if it's been served or not in all candor, but she's been directed to take out a PPO, and she has started the eviction process. But at this point, she has been out of her home since the date of this incident. I don't think that is appropriate if she owns the home. I would ask the court to allow her to return to her home. My understanding is they need to be removed from the house by what date, my dear?
The paperwork, recent paperwork, we can March 4th cycle.
And if they have not left by March 4th, she's going to have them legally ousted from her own home. This is absolutely ridiculous. And I don't know how a complaining witness comes forward in a sister fight, in essence, and thinks she can just take up residency scot-free in her sister's home and think that that's not going to be addressed.
Okay, you discussed that with your request with Mr. Mohammed?
Yes.
Mr. Mohammed?
Judge, I spoke with the victim in this case, and she indicated to me that the home is actually her mother's home. And
go ahead.
And she is 1/3 of the owner of that premise. She indicated that her sister is 1/3 owner, and then her brother's the other third owner. This crime that was committed on this day was committed by this defendant. It wasn't committed by the victim. My understanding, based off of my discussions, is she doesn't want her there. She may have started an eviction process, but there was none totally completed. I don't believe this is even the appropriate forum for that. I think that's a landlord-tenant issue, which could be motioned there. So we would object to any modification to bond. I believe this was potentially brought in front of a judge previously, and there's been no change in regards to the circumstances of this case to modify bond. So that's the people's position, Judge. Respectfully.
Ms. Marchand?
Your Honor, it's my understanding, I mean, quite frankly, the paperwork suggests that the home belongs solely to my client and that they are squatters in her house, thus the eviction process. A judge has passed on that issue, thus the eviction paperwork. And they need to be out of that house, moved by March 2nd, 2024. I would urge this court to at least make it a no assaulted contact so that she can move back into her own darn home. And if needs be, then the court can take up the issue of the eviction. But clearly it has already been signed that they are to be out by March 2nd. If they want to contest if they have any property rights, then they need a lawyer and not just the prosecutor.
Before Mr. Mohammed responds, maybe I'm missing something. I'm looking in the file and Judge Green's arraignment indicates no contact. It doesn't say don't return to the home, so I can't undo. Mr. Mohammed, you were starting to say?
And Judge, I would just say in regard to the no contact order, the people would object to removing that only because the allegations in the charges reflect, in this case, are very serious, which include unarmed robbery and felonious assault. So based on that, the people would be objecting to removing the no contact order due to the seriousness of the crime. I understand it's against sisters and it's sad to see that. I definitely understand that perspective, but again, these are two serious felonies. It's not a misdemeanor or something very small. It's unarmed robbery and it is felonious assault. Respectfully to both parties.
Understood, but we seem to have paperwork to suggest the ownership belongs to my client. The object that was alleged to have been taken is hypothetically a cell phone and hypothetically a pair of glasses. Interestingly enough, the complaining witness called 911 and they don't have a landline.
And Judge, a brief response would be the key word that Madam Counsel is using is suggest. And there's nothing to indicate concrete proof of that it's the defendant's home is solely that individual's home. So I would just like that key word to be noted. Thank you.
The court has heard the arguments. Ms. Marchand, the court will deny your request to modify bond in any way. Ms. Crossley will be bound over as charged. Next appearance date again is March the 13th at 9 a.m. If she wishes to pursue summary proceedings, that's an option. But that concludes this matter for this court, unless there's anything else, Mr. Mohammed.
Nothing from the people.
Anything else, Ms. Marchand?
No, Your Honor. Well, one, does the court have any position? Because I think she has to be there on the 2nd to confirm whether or not they're still in the house. I don't do landlord tenant, so I just want to confirm if she's going to evict them. They're supposed to be out by the 2nd. Who confirms whether or not they've actually done so? and if she has to go back to the courts and have the courts legally remove them.
How do you confirm that somebody's not living in the house
Exactly.
without having contact with that person?
Exactly.
There are ways to do that. Either there's evidence of activity at a property or there's not. And I can't imagine, given the existence of this case, that there's not some way to figure out without violating the no contact order. I don't know how to say it differently than that.
We will see what we can do at NBS to assist her in making sure the squatters are removed.
Thank you, Ms. Maishan.
Thank you.
Mr. Mohammed, I'll see you at 12:30. What's going on?
Saying hi.
Hi.
How are you?
Good. How have you been?
Very good, very good. Back vacation, so I'm even better.
Take care.
I will, thank you.
What's that?
You have been right. Are you about to level up? You guys like each go up. Just think of this one. And I turned on to it. I said, what? I got 4 years. What does it do? No. No work the nights. So wait, are you like, so what's your rate? Oh. During when they come in fresh and become a detective, they have to be awesome. 5 years. 5. So besides you three, who else is it? Oh, man, that's fine. Or, he's only here for you. And then the Keel's gonna take over. Yeah, I know Harrison well, and I know like Long well. Yeah. And then you and then I know. And then 500 cases, 200 cases. Yeah, that's a lot. Like 60.
She's just gonna hold both of you and get 10.
Great. Great. Do you have someplace else you need to be? Really?
I can.
Do you mind? How soon?
Well, just maybe one. I'm trying to find out where she's at right now. Go grab her.
We have 1 o'clock and then we have 2. We're not doing anything. We're not starting anything else after 1:30. So can you hang around for like 45 minutes or so?
Yeah, I gotta be somewhere by 1:45.
Okay, just fine. Thanks. You want to know where he is? Yes.
Oh, you don't.
Oh, wait, that's not one. Thanks.
Huh?
She feels bad because we were here for a 3-day exam.
Oh, no way. Homicide?
CSC. Oh, 3 days. That's the final. So we dismissed it.
Wait, and then they dismissed after that?
Because they caught convicting line. She made it open up. Jesus. They told someone when she charged it. Don't charge this case. They said this woman's not telling the truth. I don't believe it. So she went from speaking English to speaking only French, and then gave a statement in French. And when they did the translator, she came here and didn't understand English, allegedly. So the French interpreter was here, and she would answer the question before the interpreter interpreted. And it was a circus.
That's insane.
Yeah, it was bad.
Honestly, I think people, when they do that stuff, they should be found guilty of a crime.
And she got to stay here for asylum, because she's a victim of a crime. Because if not, she had to go back to Congo.
But then, like, how do we know she was really a victim of a crime over there?
Well,
at this point, she's like making up crimes.
Because she tried to get into Canada, and Canada said, no, you're not coming here, leave. So she came here, and then she filed for divorce on Friday, and then Monday she filed the CSC charges.
Wait, how can, was she his wife?
They were married.
So how could it be CSC?
She claimed all kinds of craziness about guns and You know, when he was playing the video and all the videos are happy, and she's like, well, he would tell me that he's gonna come rape me and tell me to turn the video off. Not to turn the video off, he'd rape me.
Oh, I thought CSE meant they were a child.
No,
Oh.
Sissy wanted to be an adult.
Oh, that's an adult.
She made it all crazy mistake.
Damn.
Goes back to you. He did the phone dumps and they were all in French, and so it was like, they're all in French. I said, I can't do anything for you. I said, here's this, you have to get an interpreter to go through all this. I said, you don't have a French interpreter. And it was like 160 some pages of text, not one text message referenced any type of assault. Talked about she loved them, she didn't divorce them, she can't believe that, you know, she's got to go back to Congo. That's now she's in trouble with, you know, federal government lying to them.
She had a federal case too.
Well, they're gonna kick her out of the country now. But she came here to the Congo, but she researched it, and the guy, the defense service, he was awesome.
Who was it?
His name was Scott Smith or something, little skinny guy with glasses. He's out. He researched everything and showed where she was, like, she had searched on her computer about red flags when you're trying to get asylum. Don't get a one-way ticket, get a round trip, so you're, you know, and she came here and did all that. So she came to Chicago, jumped the cab, took the bus to Detroit, jumped the cab over the Canadian border.
How did he know what she searched?
We got we dumped the laptop in her phone. We got all the dumps. She was an attorney too, so she was a congresswoman over there. She went to law school for 5 years, and then she went to a 2-year college in South Africa that was English speaking. She was there for 2 years. It doesn't know how to speak English. My entire interview for an hour and a half was English. I kept looking at me, I'm like, what is that?
Wait, so you went up there and acted like you didn't know English?
Yeah, yeah. She had to have an interpreter, didn't understand it. It was. And she would
Wait, someone knew this?
Someone believed her. Because I believed that this woman was telling the truth. I'm like, she's not telling the truth. None of the stuff she says matches up. You know, I said, you don't find it weird that she gets divorce paperwork on a Friday, she's gonna get deported, and Monday she comes to the next CSC report?
No, it's not even just that, and she speaks English, but then when she comes in, she only speaks French. Like, that's kind of weird.
Yeah, it was bad.
That's wild.
Yeah. Finally, Judge Mark had enough. I convinced someone, he needs to dismiss this. Yeah, but that's, you want to, yeah.
So for this case, let me get that. So for this case, I'm going to offer plea just because she does have a history. It's currently charged retail fraud first degree. I'm pretty sure it's about 2 years. How does it have her plead guilty? We have to go to trial and everything to retail fraud second degree, and then full restitution, and that way it stays here.
Yeah.
If they accept it. It's going down a step, but it's a full plea, like the case is done.
Yeah, no, I have no problem. It's here. I know what happens when it comes to chaos.
And then it just ends up. The thing is, I would love to do this for a trial because it's so straightforward and he's like going to be a great witness, but I don't want it to just go and then nothing happens. That's what I keep hearing from officers. They tell me like, after it leads here, it's going over there and there's case getting dismissed for no reason, or it's just probation.
Yeah. Get more down here.
Well, because here, my understanding, what the APA told me is these judges, this is their community, right? So they're gonna want this area safer. The probation is a lot more. They have to report here and shit. Over there, I don't know. I don't know that, but I think the reason there's a lot of like stuff like that over there is just because people to do their trials. Yeah, that too. But you know, there's a statistic that came out like a month ago that crime in Wayne County is down like over 30%. Maybe. At least that's what it said. I told my supervisor, that's who told me, I was like, you know why, right? There's a new sheriff in town. Yeah. Because I just started. Let me know. The stuff that she was taking, she recovered. And did you guys like, was there anything that got stolen? It was just closed. So you guys were able to put that up. So there's no restitution. So I'm asking, no, you covered it. I would normally put in full restitution. So it'd just be, what I'm doing, I'm gonna take it out of one step. First degree, 1,000. I was gonna reduce it one step, make it a second degree, make it a misdemeanor. To plead guilty, has to be jail. I'm gonna do lethal second and be out.
You want the camera to?
Hi, Mary Ann, can you hear me?
Mm-mm. Sorry. Oh, no, it's not.
Hello? Can anyone hear me? Uh, thank you.
You're welcome.
Good afternoon, sir. Can you hear me?
I certainly can.
Hi. What case are you here for today?
I'm here for the identity theft case against Gary Dean Taggart Jr. and Nicholas Joseph Cadle.
Boy, I don't have those on our docket. Do you have a case number, or do you have, or maybe the defendant's name again? I'll look it up and see what's going on.
Sure, one moment. Let me pull it up.
Hi, Mary Ann, can you hear me? Mr. Tiger,
I can hear you.
Okay.
I can hear you.
Hey, Mary Ann, is there a Clayton Neal that tried joining by chance?
No, there isn't. I was not yet. But I'm sorry, Mr. Taggart, what case are you here for? Do you know who this is, Mohammed?
Yeah, he's the victim for Emily Barnett.
Oh,
Thank
for
you.
Barnett. Okay. Do you need him in your breakout room?
No, we spoke yesterday, so we're just waiting for the exam. We got a court order for him to be able to testify through Zoom.
Got it. I recall that. Thank you.
You're welcome.
Mr. Mohammed, are you ready on that case?
Yeah, I mean, there's supposed to be a Clayton Neal who's supposed to appear on Zoom, but he hasn't appeared then.
Okay.
Well, and I'll say my husband, Nick Cadle, is supposed to be appearing as well. He's actually in the office today, but was supposed to be joining us, and he is not here yet. So I just sent him a quick note to see where he was.
But Mr. Mohammed, when they arrive, are you ready to go?
Yeah, I'm ready. Yes.
Okay, thank you.
Of course.
Oh, looks like Nick is connecting to the audio as we speak, so he's joining now.
Okay. Hi, Mr. Tiger. Hi, Mr. Cadell.
Hello.
Hi. You have any questions for me? We can go to breakout room if you need me for anything. Okay.
So.
Okay, so we're just waiting on Mohammed.
Okay.
Okay.
folks hear me?
I did.
Thank you.
Yeah. I mean, it's scheduled to be busy, but it hasn't been that crazy. Definitely.
My days are like, I feel like I don't have much going on, and then once I sit down,
So how many exams do you guys usually have a day?
like per person, it just depends on, I guess, your caseload. I probably have like 3 a week, maybe.
Oh, that's it?
Mhm.
Oh, damn.
Yeah. Hello. It's warmer, right? Okay, good. Shivering. You smell good. Some of my clients that are in the jail have that. Yeah, she called me after yeah, I told her to call her and let her know what happens, and then she said that she will depending on what happens.
I know that.
Yeah, I think she was nice when I seen her and she was in front of her. She was very spoken, like respectful. She's older. I mean, obviously older than us, but like 40s, 50s, maybe. Like not. I definitely would not say she's in her 60s, and if she is, she looks thick. Yeah. Yeah. So he actually switched to a different courtroom altogether. So he's not even in that courtroom. I know.
Alyssa,
Yeah.
have you had a jury trial?
Not yet. No.
I have my first one on Friday.
Oh God. On what?
Assault and battery.
Okay.
It's here.
That's exciting.
Here.
Are you prepped?
No. I mean, I feel like I'll be okay.
Yeah.
I haven't prepped as much as I would like.
Yeah.
But I'll be okay.
Yeah.
I had a bench trial too last week.
Oh, that's nice. In front of her?
No, it was Tina Green.
Oh, okay. Oh, really?
Yeah.
I've never seen her. She's in.
She's here.
Yeah.
She's like the one all the way there.
Oh, that way. Okay. I've never seen her. I think I was like in front of her one time for a PCC.
She's funny.
What was the case?
That one was domestic violence.
Oh, okay. Was that?
It was still.
If they come, I feel like it's gonna be.
It's tough when there's no one video that credibility.
Right.
When I got to do cross, I see that hard.
Oh, we keep the defendant testify?
Yeah, and that's what I think the mistake was by the defendant. That's where I made like this.
Right. Yeah, well, you just show the defendant like that they like you try to get them agitated.
Yeah.
So you can show that they're, you know.
He was drinking. I think also he was drinking.
Right, right. Wow.
It was just cool because I never get to do leading.
Right. Yeah, yeah, that's true. You never really get to cross much. So D is the, I think, cause. They're married. So it's essentially both their cards. I think his middle name is Dean. He goes by Dean.
All right.
You may be seated. This is 230637 FY. This is State of Michigan versus Emily Barnett. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
And good afternoon, Your Honor. Alyssa Segura with the Neighborhood Defender Service on behalf of Emily Barnett, P86422. Ms. Barnett, will you please state your name for the record?
Emily Barnett.
Thank you, Ms. Barnett. You may be seated.
Thank you.
Today is the day and time scheduled for the preliminary examination. In this matter, there is count one, identity theft. Are the people prepared to proceed?
Judge, the people are prepared to move forward. However, we do not have former officer Clayton Neal here present. I spoke to him yesterday and he indicated to me that he's in another state for school and he will not be returning for the next 6 months. He was present at the previous hearing. However, since then, he started a program in another state and he will not be returning to the state of Michigan for 6 months. So at this time, I'd like to request if this court allows held in part, get the testimony of these two individuals, and then at that later session, finish it off with former officer Clayton Neal.
Ma'am.
Yes, Your Honor. I would object to that request. 6 months is a very long time. This case is originated from August of last year. So we are already pushing over 6 months now since the first allegation. It is my understanding that there was a motion filed last night around 9:30 p.m. Where Mr. Mohammed informed the court of this information. I would like to bring notice that this was scheduled in January 7th or January 17th. Over a month ago, and we were just not hearing information about this at 9:30 at night, those nights prior. So I would definitely object, considering that that is just not enough notice. And further, this court is aware that Ms. Barnett is facing charges in circuit court on a second-degree homicide, and that trial is set to take place in July, which would be 6 months from now, would put us past that July date. And I think that there's just this case is really holding Ms. Barnett back as far as bond and things of that nature. So it would be extremely prejudicial for Ms. Barnett for us to have today's hearing and then in 6 months, possibly longer than that, come back to have the hearing again. So for those reasons, I would object.
Maybe I misunderstood your request, Mr. Mohammed. What the court received was a motion to adjourn preliminary examination for a good cause, but in the body of the motion, it indicates that because Officer Neal is out of state, the people were requesting that he testify by Zoom. So the court's understanding, well, reading between the lines, was that he would be on this afternoon.
Yes, Judge. So the motion that I sent yesterday was to allow him to testify through Zoom. However, I didn't receive any response, and I know I sent it very late, and I wasn't expecting a response yesterday or anything like that. However, I did speak to him yesterday, and I did ask him to show up on Zoom over the phone at 1 p.m. I did do that. However, I don't see him here. I don't know if he's in a school program or like currently. I don't know what the deal is. I just know that I do have these two victims that are the center of this case. Officer Neal will largely be playing the role of the identification. Like he responded to the location and he observed this individual in that hotel room, and that's primarily what he will be used for. As far as everything else, it's going to be coming through these two witnesses, Judge. I understand at the previous hearing on January 17th that defense counsel just mentioned Officer Clayton Neal was here on that day. However, we weren't able to proceed on that day. I don't know if there was an issue with writing the defendant out or what exactly happened, but all parties were here. They've been here multiple times, and we are prepared to move forward today. We would just be respectfully requesting for a held in part just for Officer Clayton Neal's testimony.
Here's my concern. On September 13th of 23, we scheduled the exam for November the 29th. We appeared that day and the case was adjourned because of the allegation that there will be counts added to this file. We reset the exam for January 17th. On January 17th, Ms. Barnett was not transported because she was in custody on her other file. It had nothing to do with this court not sending the writ. It was that she was not brought for other reasons. Mr. Taggart was here, Mr. Cadell was here, and Officer Neal was here. So respectfully, Mr. Gore, I'm inclined to allow an adjournment of this matter, not for 6 months. I don't want to start taking testimony and then try to find another day and interfere with Ms. Barnett's other cases, but Mr. Taggart's here, Mr. Cadell's are here, and it just, do you two need a moment to speak, or have you already talked about a possible way to move forward today?
I just had one thing to say, Your Honor. I spoke with the officer in charge last time we were here, and he indicated that the individual, the only officer that was here the last time was Marcus Holmes, not Clayton Neal. And so I just, and Your Honor, I don't remember seeing, and not to bring race into this, but I didn't see a Caucasian officer here. I've seen an African-American officer here, and Mr. Holmes, or Officer Holmes, is the African-American male in this matter, and I did not see Clayton Neal, who is the Caucasian male. So I would just put that on the record. There's nothing to indicate that he was here, at least if there's records. So that would just be my only concern.
Judge, may I respond briefly?
Absolutely.
Judge, so the first case where Officer Neal did not appear is when I spoke to Alyssa and I advised her that, hey, you know, this was before we knew Officer Neal wasn't going to be showing up. I think the testimony is going to reflect additional charges. If the testimony reflects those charges, I plan on adding it. However, on that day, Officer Neal failed to appear. OIC was here. He indicated to me there was trouble to provide him with a subpoena because he was released from the police. He no longer works there, and it was like some kind of bad terms or something along those lines. So he had difficulty giving him his subpoena. I brought all of this to the attention of the court. The court adjourned on that day. The next hearing that we had was another preliminary exam. At that preliminary exam, Officer Williams did not appear. However, Officer Neal appeared. Officer Williams appeared at the first hearing, but he did not appear at the second hearing. Officer Williams is the African-American police officer that Alyssa is referring to. Officer Neal, the Caucasian individual, the officer who didn't appear at the first hearing, he was here in person at the last hearing. I'm an officer of the court, and I give you my word that he was here. I spoke to him. Officer Perkins, the officer in charge of this case, spoke to him, and he told me, remember last time when we were talking to Officer Clayton Neal regarding a certain situation. So he will also, testify for the record if needed that Officer Clayton Neal was here at the last hearing.
Mr. Muhammad and Mr. Gore, respectfully, I don't know that we need to get that far. This is preliminary examination. Did something happen and was Ms. Barnett involved? And if you're saying, if Mr. Muhammad, you're saying that without Officer Neal or former Officer Neal, we can't even hold the preliminary in its entirety today.
Correct.
And so you're asking for an adjournment. I don't want to stop and start and stop and start because people lose track of it and other things come up and people get busy and scheduled in other courts. If that's your position, Mr. Gore, you would object to this court adjourning this matter?
I would, yes, Your Honor, just because we've been here so many times and I know that there's been issues every single time. But there's just more important things going on in Ms. Barnett's. And I'm not saying that this case is not important, but it would just delay and further prejudice her. Just to bring to the court's attention, she did have a bond hearing in circuit court. They indicated that depending on what happens here today, that they would address her bond. Unfortunately, now that can't happen because today isn't happening, and we're going to adjourn this matter 6 months, maybe more down the road. And that would be after her homicide case goes to trial. So she would be waiting in there without the opportunity to address her bond. And so there was a lot on the line today. I'm going to be honest with Ms. Barnett. And so that's why we'd be asking, because it'd be very prejudicial to her for this case to be adjourned.
You asked for the first adjournment because of the allegations that there would be at least 4 additional counts added. The second adjournment was based on Ms. Barnett, not being transported, which is beyond the control of any of us in this courtroom. And now the court sees this as the prosecution's first request for an adjournment. Do you see it differently?
No, I mean, I agree, Your Honor. And I think that it's just, it's unfortunate now because then he was saying the very first preliminary exam, he was saying he was going to add upwards of 7 new charges. And now today he's only going forward on the identity theft. And so had that allegation not been made at the very first preliminary exam, we wouldn't be here today. And so I think that is definitely should be taken into consideration because we were ready to proceed on that very first day. But then obviously I wanted to be properly prepared. And so I do take that upon myself, wanting that adjournment. But now here we are, no additional charges would have been added. And we're just delaying this process so much longer than it necessarily needs to be, but I understand and respect whatever decision the court makes.
And Judge, I'd like to respond. I believe there was a misrepresentation. There was never 7. I think it was about 4, and it would include, and I'm just off of the top of my head, which would include lying to a police officer, which she did maybe 4 or 5 times in that case. She also used fraudulent. She used a device which was a credit card she was not authorized to use. And I can't recall the other 2 off the top of my head. I have my paperwork in my office. I can go get it if you need. I remember stating them very clearly for the record on that day. I also followed it up with an email to Alyssa prior to the exam stating the statute that I was going to be using for each charge. We had a brief discussion. I told her it seems like everything's going to be going through Zoom today. So I think for those reasons, due to everything coming through Zoom, I think it's fair to just stick with just the identity theft. That was just purely because of everything's being through Zoom. It's convenient to the court. It's clear, it's concise. That was the reason that I told her, let's just move forward with just the identity theft. But the record will reflect 4 additional counts, the 4 counts that I mentioned previously. Just to be clear for the record.
Do you have your adjourned dates? The court, having heard the argument of the attorneys, the court will grant the prosecution's request to adjourn this matter. Our next available date, Ms. Barnett's not in custody because of this case, correct?
No, that's correct.
It's not impacting her ability to post and be released, correct?
No, I think she has a personal bond, and we would ask for a nominal bond just so she can earn credit. I think her bond on her other case is, I think I want to say it's 100,000, 10%. No, just 100,000.
So you want to amend the bond in this file? Is that what you're saying?
Yeah, I just want a nominal bond on this file so that she can start earning credit for the time that she's gonna be in.
Any objection, Mr. Mohammed?
No, Judge.
The bond is currently 5,000 personal with 5,000, 10%.
That works for me.
5,000, 10%. We will adjourn this exam. Mr. Taggart and Mr. Cadell, my apologies, but we are adjourning the exam to April 3rd at 2:30 p.m. And the notes on the ROA reflect that this adjournment is being charged to the prosecution, that the two complainants were present as the only witnesses present, and we're amending the bond as indicated. If Officer Neal, or whatever his honorific is at this time, needs to appear by Zoom at the April 3rd date, he may appear by Zoom, but we are not adjourning this matter. Again, Ms. Segura is correct. It has now been adjourned multiple times, once charged to the defendants, once charged to the prosecution, and once because of the failure of transport. Is there anything else, Mr. Mohammed?
Judge, just for the record, I want it to be clear, I will be moving forward with just identity theft. And the reason is for the convenience for the court, due to, it appears all the testimony is gonna be coming through Zoom. I think that it's just gonna be making things a little.
You're not doing anything for the court's convenience. You're doing it for your office, because this court is here 8 to 4 Monday through Friday. If you wanted to add counts, you could have done that after we appeared in November. No disrespect to you, sir, but don't put it on the court. The court will hear as much testimony as is necessary. Ms. Segura, anything else on behalf of Ms. Barnett?
Respectfully, Judge, then I'll reserve the right to add those additional counts then at the previous. And I will send an email to Attorney Segura if those counts will be added.
We'll take it up on April 3rd. Thank you all. Have a good day.
Thank you.
Are we ready with Ms. Griffin? Thank you. I know you need a moment. It's fine.
I'm sorry. I won't bite, I promise. I'm good, how are you?
I think it was the two of them last time. When Ms. Segura was fighting in the hallway. I think it was Ms. Hamilton and Ms. Segura.
Who, me? Oh, we were fighting?
No, not the two of you.
Oh.
But I think on November 29th, I think that you were here on that day too, weren't you?
Oh, God, that was so long.
That was one of those Wednesday afternoons that are the Wednesdays ever.
Oh, yeah, that was a Wednesday.
Mm-hmm.
There was a day when everything was really windy now.
Yes, all right. All right, well, thank you. Have a good day.
You too, ma'am. So by the time you come back, we will switch over again and be Easter ready.
Yeah, those are cute.
I try. I cannot, I have a beaded shamrock that is a table thing. I can't find it. I was looking for it yesterday.
So I need to give you the PTR, right, Ken? I'm sorry. I need to give you the PTR for her.
Yes.
Okay. I'm gonna go back real quick and have it. Put that off. Yeah, and but you know what? What? I heard you say that, and I was like, I don't get, let me see the words.
Judge, we're ready.
I just need a recorder. Silly me, we don't have proceedings without recorders. Oh. Bettendorf, He has somewhere to be at 1:45.
Yeah, he's gone, but it's okay. He's
Okay.
not gonna be called.
Am I ready to go? Let's finish the paperwork for.
Can I, do I have time to?
Yeah.
All right, you know.
Thank you. This is 230929 FY, State of Michigan versus Griffin. May I have your appearances, please?
Good morning, Your Honor. Mohammed on behalf of PA-6-771.
And good morning, Your Honor, good afternoon, Your Honor. Vanessa Hamilton, PA-2107, on behalf of the Chanel Griffin, stands to my right. Your same name for the record, Chanel Griffin.
Thank you, Ms. Griffin. Today is the day and time set for the preliminary examination in this matter. There is count one, retail fraud, first degree. Are the people prepared to proceed?
Yes, Judge, people are prepared to proceed. As a preliminary matter, we'd like to request a mutual order of sequestration.
Is the defense ready to proceed?
Yes, Your Honor.
As a procedural matter, the request for mutual sequestration is granted. If there is anyone who is watching these proceedings who may at some point be required to provide testimony, you should cease viewing this live stream at this time. The courtroom having no one in it who would be subject to that order. Is there anything else preliminarily, Mr. Mohammed?
Not from the people.
Any preliminary matters on behalf of the defense?
No, Your Honor.
Thank you. Mr. Mohammed.
People call Caleb Haley to the stand.
Sir, I'm going to have you come up to this podium for me, please. State your first and last name and spell them both for the record.
Caleb Haley, Caleb Haley.
Mr. Haley, raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Please come have a seat in this black chair that's closest to me. My secretary is recording your testimony. If she's unable to hear you, I'll ask you to either raise your voice or move yourself closer to that microphone, okay? Mr. Mohammed.
Good afternoon, Mr. Haley. Can you please restate your name for the record?
My name is Caleb Haley, Caleb Haley.
Mr. Haley, I'm going to take you back to the day of August 26, 2020. I'm sorry, August 26, 2023. Were you at or near the location of 10562 Belleville Road?
Yes.
Is that located in Van Buren Township?
Yes.
In the county of Wayne?
Yes.
What's at that location?
Walmart.
And what took you to that location on August 26, 2023?
I am employed there as an asset protection investigator.
Okay, and while at that location, did you observe something that drew your attention?
Yes.
What did you observe?
I observed a female wearing all black with Walmart reusable bags in the aisles of clothing.
And what about that drew your attention?
It's typical for reusable bags to be used as concealment for people.
Okay, upon that observation, what, if anything, did you do?
I continued surveillance and I observed the suspect selecting and concealing into the bags from the shelf.
That individual that you observed taking items from the shelves and putting them into that bag, do you see that individual in the courtroom today?
Yes, she's sitting right over there.
Okay. Can you please point to that individual and point out an article of clothing that individual is wearing?
Green jacket.
Your Honor, please let the record reflect he has pointed to and identified the defendant.
Yes, sir.
Okay, upon those observations, what did you do or observe next?
I continued surveillance. I followed her around. I watched her go into the women's section of clothing and get some women's underwear and put it into the bag. I then observed her going into the liquor department and selecting a bottle of liquor and putting it in the bags as well. After that, I observed her going up to the front of the store and passing the point of sale.
Okay, so you mentioned that you observed her pick out items and put them in bags, and you used the word bags, plural. How many bags did this individual have on them at this location?
About 4 to 5.
Okay, and approximately how many items were chosen that you observed?
I cannot recall.
Okay, would referring to your report refresh your recollection?
Yes.
Your Honor, may I approach with this individual's report?
Yes, sir.
I will hand it to you. Okay, has your memory been refreshed?
Yes.
Okay, you can go ahead with the answer.
Can you read?
So how many items did you observe that individual placing in those bags?
I observed the home projector.
Do you know the cost of that home projector?
Not off the top of my head, no.
Is it in your report?
I do not believe so, no.
Okay. You can continue. So you observed the home projector. What else?
Pillowcases, 2 pillowcases. A knife set as well.
Just or rather, just is he reading directly from the report?
Please refer to the report. Refresh your recollection. Once it's been refreshed, look up at me and then can answer.
Thank you, Attorney Hamilton.
I also observed her with the clothes. I do not recall how many articles of clothing she had.
Okay. So, okay, you mentioned she had 4 to 5 bags. Were these bags full?
Yes.
Were all the bags full?
Yes.
Okay. Do you recall how much in total was the amount that was taken? Or approximately?
Around $900.
Okay. After you observed this individual place those items, you mentioned that you observed her past the point of sale. Can you describe what that means?
Past the point of sale for us at Walmart is past the register without offering any payment. And that is passing the self-checkouts and the man registers and going into the section in between the 2 doors called the vestibule. That is where we apprehend people and present ourselves as Walmart asset protection.
Okay. And you did that with this individual, correct?
Yes.
Nothing further, Judge.
Thank you. Attorney Hamilton?
So I just wanted to get a little bit more information about your role specifically. Could you just briefly describe to me what it means to be, I think you said asset protection?
Mm-hmm.
Could you explain that to me?
Being an asset protection investigator, I assume the role of not just identifying theft in the store, but also preventing it, as well as preventing associate harm and safety issues as well.
Okay, so like the majority of your job is kind of dealing with these issues primarily. You don't do anything else besides dealing with what you just listed.
Correct.
And so what you were doing on that day was fairly normal for your everyday, is that correct?
Yes.
And so you say that you saw my client with Walmart reusable bags, correct?
Yes.
And were all of these Walmart reusable bags?
Yes.
Okay. And are these bags that are sold at Walmart?
Yes.
Okay. And so would you say it's pretty typical that people will use reusable bags in a Walmart store?
Yes.
And the things that you saw my client purchasing, picking up, at least from what you said, sound like they were all normal items, right?
Yes.
And like clothing, some food items, I think you said.
Yes.
And so you eventually saw her take these items past the point of sale, right?
Yes.
And at that point, you apprehended her. What does apprehend mean?
Stopping her at the door.
Okay. And so you stopped her at the door. And at what point did the police become involved?
I was on the phone with the police at the time of me approaching her and confronting her as asset protection for Walmart.
Okay, so did they get there shortly thereafter?
Yes, less than a minute after.
Okay. No further questions.
Thank you. Any redirect, Mr. Mohammed?
Nothing further, Judge.
Thank you. Mr. Haley, you may step down. Thank you for your testimony. Your next witness, sir.
Judge, the people have no further witnesses.
Attorney Hamilton.
Nothing further to add, Your Honor.
Argument.
Judge, the people move for a bind over. The testimony today reflects that this individual who was identified in court was at the location of 10562 Belleville Road, which is a Walmart. This individual was observed by this individual who was testifying today, Mr. Caleb Haley, as putting items in her fortified bags that were full. She passed the point of sales without offering to pay. We believe we've met the amount was over $800. We believe we've met the probable cause standard based off of this testimony. So we move for a bind over, Judge. I reserve any rebuttal. Thank you.
And Judge, I would just like to respond and ask that this case not be bound over and ask that you dismiss it. I don't think that the prosecutors met the burden to establish or present evidence for every single element of this crime. First and foremost, the elements, I guess, of retail theft are that property was taken from a store, there was some kind of movement, and most importantly, Your Honor, that there should be some sort of intent. I've heard absolutely no evidence here suggesting that my client intended to steal, permanently deprive any property from the store. We just hear that she put some items in the cart and passed the point of sale. We don't hear any thing else. It sounds like she was contacted pretty much immediately as that happened. It sounded like perhaps she was contacted by police, but we don't know what exactly occurred after that point. And I don't believe that there's necessarily an intent to steal. There's a lot of reasons why people might pass registers in a store. For example, I know Walmart, they have, as I think we all are familiar with, many different other stores, food stores, there's different, I think, ATMs and, rides that kids can play with, and Coinstar and banks, and all of these things are past the point of sale. I've heard absolutely no testimony that suggests that she was trying to deprive the store permanently of these items. I've just heard that she walked past the registers, and at that point, this employee was already on the phone with the police and making contact with her, apprehending her. And I've also heard no testimony to actual value of the items. I've heard that, yes, there were multiple items that were taken. I've heard that bags were full, but I've not heard any sort of testimony as to what they are. And from what I've heard, it's simple food items, right? Simple clothing items. And so I'm not sure if that meets the first degree requisite of $1,000 or more. In fact, retail theft has multiple different degrees, all based off of the amount of something that was taken. Third degree, I believe, speaks to an amount less than $200. So I'm not sure if we've met the 200 or to 1,000 for second degree. I'm not sure we've met the first degree because I'm not sure we've met or established that these items had any value. Obviously, we can assume they had some sort of value. But yes, so I don't feel that there's been any kind of testimony as to multiple elements of this crime, and so I don't think that the prosecutors met their burden and ask that you dismiss the case.
Judge, the testimony reflects more than food items. It also includes a home projector system that I believe was mentioned. Also, it doesn't have to be more than $1,000. It has to be more than $200 and less than 1,000. Just in regards to the price element. In regards to just putting items in her bags, across the point of sales, we have registers for a reason, and that's to pay for the items you're taking from the store. She failed to do that. Not just that, she passed the point of sales and was around the exit area where she was approached by the loss prevention officer, who shortly then followed it up by calling the police. Again, this is a probable cause standard that we have in these cases, and we believe that at the very least, question of fact for the trier of fact has been met. So I still request to have this case found over. Thank you.
Thank you. The court did have the opportunity to hear the testimony of Mr. Haley this afternoon. He indicated that he was an employee of Walmart acting as an asset protection investigator and noted that Ms. Griffin did secret away underwear, liquor, a projector, pillowcases, knife set, and he put that value of at $900. For purposes of exam, the court will find that the people have met their burden for the sole count in this matter of retail fraud first degree. Ms. Griffin, the next step in these proceedings is that you will be bound over for arraignment on the information that will happen on March 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any of its conditions will continue. Is there anything else, Mr. Mohammed?
Nothing from the people, thank you.
Anything else, Attorney Hamilton?
No, you're not.
Thank you. That concludes this matter. You have a good day. You're welcome. No worries. Thank you for being persistent in getting here.
Well, I knew he wasn't a defense attorney. And then I went on board on it a little bit. So. For preliminary examination, that is just scared of those this is not trial, this is just any government case or district court. So there are no trials here, not felony. We do misdemeanor cases, civil cases. Felony cases start here with hearing. An exam, or defendant will come with their attorney and say, no. There's a disputed sentence. And my coach started working. They're not insufficient evidence. Or she'll go in or any number of things. Is it? It's terrible. I don't know. Giving out food. Are you ready? Michelle, you got 2:30, but I asked Michelle.
Yeah, so Michelle is here. I'm ready, but I don't think it's wrong.
We don't have a choice, but prosecutor's office assigned their assistant prosecutor. Every time the door open, oh, every time I have a all right. That's real. You don't know your talk. But I did. Yeah, because she did her constitution on
cashier, she talked about how she started off and how they were from her store and how she got how she doesn't want what she asked and she ends up on obituary, nor does she want funeral. But Sunday was celebrating. Told that when she, you know, she's yeah. Is that why there's a oh, yeah, we have to be out there by one, because that other two. So she said, I mean, ask her to not change, stuff. But no, I'm sure that, I mean, we will not change the room. I'm expecting at least 100 people to know about her. And other things, this is really one of my favorite people. But anyway, she's didn't want this, but she got it. Yeah. No, I didn't see this with that, but I maybe can talk to Mark and Brian Sunday. And yes, big pain, awesome, not the pain. But then, Mary and Wesley died, she was ready to go. So fine, her quiet out. So she passed too. So that's, I'm glad, but it's sad. She was getting Meals on Wheels. That day she was right by the door in a wheelchair. She was on that. She's crying. She should have been alone. Yeah, people coming in, you know. Shopping and stuff. She's paying. Whatever it was.
Mary Ann,
Yes, Judge.
were you looking for me?
Yeah, I thought I heard you out there, and I just wanted to make sure that things weren't happening already.
I am. I'm on my way.
You're on your way to your desk?
Yes, ma'am.
Okay, I'm coming out.
Thank you.
Yep.
Thank you. So we moved up, but no one contacted, here. So he's working on it, and I just saw some stuff, so. Okay. Okay. Thank you. Thank you.
John's coming upstairs from us, so we should.
Okay.
5 minutes.
Okay, I'll be back out.
Okay.
Of course, ma'am.
You have a nice chair. Look what I have to sit in.
This is Judge Parrott's chair. This is my predecessor's chair. So I kept it because it fits with the courtroom. Mackenzie? I know, I felt that.
It feels good in here. Yeah, it's got super cold. It's breezy. I didn't know where.
It's the temperature around about 40 degrees for it's still here.
For next week, I don't know what this is. It says juvenile hearing.
That's not me.
No, I think
It's Judge Oakley. You'd have to ask Heather about that.
I've never seen a juvenile.
Good afternoon, sir. I was gonna say good morning out of force of habit, but
Yes, it sometimes feels like a very long morning when we're still here. Good afternoon.
good afternoon. This is 210736FY. This is State of Michigan versus Frank Michaud. May I have your appearances, please?
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
Would you state your name for the record, sir?
My name is Frank Michaud. I am the beneficiary of the Frank Anthony Michaud estate that you are administrating over, and I appoint you as the trustee for the record, let the record show. I am here as a making a special appearance, not general. I am here on the threat, duress, and coercion.
Thank you, Mr. Michaud. Today is the day and time scheduled for the preliminary examination. In this matter, there is count 1, weapons, firearms, possession by felon. Count 2, carrying concealed weapon. Count 3, felony firearm. Are the people prepared to proceed?
We are, Your Honor. We do have a couple of preliminary matters.
Before we do that, Mr. Michaud, are you prepared to proceed?
No, ma'am. I'm actually here to get a better understanding of things first before any proceedings.
What is it that you need to get a better understanding of, sir?
For one, is the jurisdiction that the court is operating upon.
Judge, I'm gonna object. The court has made a decision on this motion previously. Both you and Judge Oakley have ruled on this, so I'm gonna object.
Mr. Mohammed, hold on one second. Mr. Mohammed, what we will do is let Mr. Michaud make his record.
Yes, ma'am. Okay. Constitution, the Sixth Amendment grants me the right to know the nature and the cause of the action. I know the jurisdiction that you're operating upon for the record.
The next thing, sir. The next thing. You said you had some preliminary matters, which suggests more than one thing.
Oh, yes, the jurisdiction of the court.
Okay.
Okay. You're going to.
Anything else?
Yes.
What's next?
Is this going to be criminal, civil or criminal? And I also want to. With the basis of that answer, I would like to address some other things as well.
What other things, sir?
It's pertaining to off your answer. So.
Mr. Michaud, I think we had this conversation last week. Correct me if I'm wrong. This is a criminal case. It is alleged that on February 23rd, 2021, at the Detroit Metro Airport, which is located in the city of Romulus, you committed the following: that you did possess and or transport and or purchase a firearm when ineligible to do so because you've been convicted of violation of Controlled Substance Act 333.74012 4012A4, a specified felony, and the requirements for regaining eligibility had not been met. Contrary to MCL 750.224F, count 2, carrying concealed weapon, that you did carry a dangerous weapon, to wit, a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, to wit, a range rover. Contrary to MCL 750.224. Count 3, felony firearm, that you did carry or have in your possession a firearm, to wit, a pistol, at the time you committed or attempt to commit a felony, to wit, felon in possession of a firearm. Contrary to MCL 750.227B, there is also an habitual offender third offense notice on the file where it's alleged that you were convicted of the offense of violation of Controlled Substance Act on October 24, 2013, and convicted of the offense of attempt carrying of a concealed weapon on April 30th, 2002. That being the case, the court having responded to the charges indicated to you that this is a criminal matter, the court's question back to you, sir, is are you prepared to proceed with the exam in this matter?
No. You still haven't stated the jurisdiction of the court for the record.
I have identified this court as the 34th District Court to you before, sir, and I will renew that indication to you. Are you prepared to proceed with the exam?
No, because Oakley stated that the jurisdiction of the court was Michigan statutes, and that's not what you're saying today.
Chief Judge Brian Oakley, you had a conversation with him about a month ago. We're having a conversation, well, we're having a hearing today. And sir, we're doing one of three things today. We are proceeding with the exam, you're waiving the exam, or we're adjourning this matter. Your response to my question right now is one of those three things. What are we doing this afternoon?
And you also stated that you addressed me having questions, and I had another question pertaining off your answer, and I wanted to read that.
Mr. Michaud, no, we're not doing this afternoon. Exam, waiver.
Well, at this moment, okay, since I'm under threat, arrest, and coercion, I would like to appoint Mr. Sullivan as trustee for the.
Mr. Michaud, you're not under any threat. This is a court. You've appeared this afternoon. This case has been called. And if you're prepared to proceed with Mr. Sullivan sitting to your left, this court will proceed. Is that what you're indicating?
Well, you say I'm not under threat, right? And if I continue to ask a question, I will be held in contempt, which is a threat, right?
I never said contempt, sir.
Well,
What we are is scheduled for a hearing. And what this court does is hearings. And I entertained some of your questions, but it is now 2:15. And the courts, I know, sir, but I'm presuming that there will be some testimony.
Okay, but you're asking me, am I ready to proceed? And while you're asking me, you also telling me that we're about to proceed. So you're not actually giving me the right to answer the question. You also making it seem like you're threatening me. So
Mr. Michaud, I'm interrupting you to tell you that I'm not threatening you,
okay,
but I've answered all that needs to be answered from this court to proceed with either the exam, a waiver.
Okay, all right. But you haven't answered the questions that I have asked. I said I had another question, and you're still not allowing me to ask the question. So do I have the right to ask?
What's your question, Mr. Michaud?
Okay, I just want to ask you, far as, hold on one second. I want to read this for you.
No, sir. You had a question. What is your question?
Can you help me understand this? Okay, according to 27 CFR 7211, it say all crimes are commercial and must have nature and cause and be prosecuted in the name of the people of the states as a real party in interest, not the people of the state, the corporation, the fiction. This is 20 FCFR, right? So I'll need you to elaborate on this code for me, please, and thank you.
Mr. Michaud, this court will decline to elaborate or respond to that because this afternoon we are here to determine if the prosecution is able to show that a crime has been committed and that probable cause exists to believe that you are in commission of that crime. That is what we're doing this afternoon.
I understand, but
Okay.
this says that possession of a deadly weapon is a commercial crime, so we have to make, I need to have a better understanding if this is a commercial crime. You said this is a crime, and there is no injured party where I hurt anyone. You haven't gave me the right to face my accuser, and it tells me under this code, 27 CFR 72.11, all crimes are commercial. A deadly weapon is considered a commercial crime. So how, if, I understand that commercial is civil, but you telling me this is criminal. So how is it criminal? And it says if there must be an injured party for a corpus delicti, for the record, an injured party, and you haven't presented an injured party for the record. So, I mean, can you elaborate on what jurisdiction you operating under? Is this civil or criminal? Because it doesn't make sense to me. So,
Mr. Michaud, you're asking a compound question, so I'm going to try to answer it. Last week and just now, you indicated a right to face your accusers. And you indicated that the court will be presenting something. The court is not presenting anything. The court will take testimony this afternoon and review evidence, documents, videos, whatever it is that either Mr. Mohammed or Mr. Sullivan on your behalf presents to this court. You want the right to face your accusers. I don't know who Mr. Mohammed is calling to give testimony this afternoon. I don't know who, if anyone, Mr. Sullivan is calling to give testimony this afternoon. That being the case, sir, are you prepared to proceed with the exam?
okay, so the Chief Oakley said that he stated for the record that my accuser was the state of Michigan. And here in this code, it says, the prosecuted in the name of the people of the states, not as the people of the state of Michigan. So what he said is contradiction to this code, and it's 27 Code of Federal Regulations 27/7211. All crimes are commercial. So I still need to, I don't understand.
You were in front of Judge Oakley for a probable cause conference, which is basically a scheduling. Are we having an exam? Is there a plea or is there a waiver? For some reason, that didn't happen with Judge Oakley. You then had a PCC with Judge Green. Then you were with me for PCC last week. I asked you questions, you wouldn't respond, but I tried to answer your questions. And the people twice demanded an exam. And when you would not answer my questions, I scheduled the exam. Mr. Michaud, your only response right now is yes or no. Are you prepared to proceed with the exam this afternoon?
Well, under threat and threat and duress of coercion, I appoint Sullivan as my trustee for the record.
Mr. Sullivan, are you prepared to proceed this afternoon?
I am prepared to conduct a preliminary exam, yes.
Thank you. Your first witness, sir.
Judge, I do have a couple preliminary matters.
What are your preliminary matters, sir?
Pursuant to, well, first I'll start off and request a mutual order of sequestration.
Any objection?
No objection.
If there is anyone in this courtroom or anyone who is viewing these proceedings, as this court is live streaming as it does most of his exams, you should stop watching the live stream. If you're in this courtroom and intend to give testimony, not just today, but at any point in the future, you should exit yourself from this courtroom at this time. Is there anyone in this courtroom other than Mr. Michaud who is potentially a witness to this matter or will provide testimony in this matter? No response?
Judge, I believe that Crystal Watley was excused at the previous hearing by Judge Chief Oakley. And so we're requesting that she be excused.
Mr. Mohammed, I don't know. I know there are 4 people. One of them, I know who it is. The other 3, I don't know who they are. I have asked if there's anyone in this court's gallery or anyone who is viewing this court's YouTube live stream of this case. If you are giving testimony this afternoon or intend to give testimony at any point during the life of this case, that you stop viewing these proceedings or exit the courtroom.
So Ms. Watley is not present, but there is someone in court who may be a defense witness in the future, and so I am gonna.
Maybe I wasn't clear when I asked them to absent themselves from the courtroom. Your next preliminary matter.
Judge, pursuant to 76611B, the people would like to introduce into evidence a certified record of conviction, which would show that this individual was not allowed to be carrying a firearm on the day in question.
Mr. Sullivan.
Judge, I would object. I would note that this is a conviction from 2002. I don't believe that constitutes like a life ban on possession of weapons. This is over 20 years ago. So I would object on that basis.
Judge, my response is I will be citing People versus Perkins, which would indicate that the defense has the burden of producing evidence that the defendant's firearm rights have been restored, and I have printed out that case law for you to review if needed. However, that case law is People versus Perkins. May I approach with both the certified record of conviction and the case law?
You may approach.
Thank you.
Any other preliminary matters, Mr. Mohammed?
Nothing from the people, Judge.
Any preliminary matters, Mr. Sullivan?
None at this time, Judge.
Thank you. Your first witness, sir.
And Judge, just briefly, in regards to our preliminary matter of mutual order sequestration, I'm also requesting an exception to the officer in charge, Detective Carmona, who's sitting to my left.
Any objection, Mr. Sullivan?
I would object, Judge, if the witness is going to be if the detective is going to be a witness at any point in the case in the future. He's allowed to remain today, then I would expect he's never going to be witness in the case, not a trial, not a hearing.
Mr. Sullivan, I believe it's been the practice and procedure that the officers in charge are allowed to remain in the courtroom during the exam. So over your objection, the court will allow Detective Carmona to remain in the courtroom. Mr. Mohammed.
Thank you, Judge. The people call Officer Jonathan Steppen.
Sir, would you stop at this podium, state your first and last name, and then spell them both for the record?
Jonathan, Jonathan, Steppen, Steppin.
Raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please come have a seat in this black chair that's closest to me. Mary Ann, my secretary, is recording your testimony. If she's unable to hear you, I'll ask you to either keep your voice up or move yourself closer to the microphone, okay? Thank you. Mr. Mohammed.
Good afternoon, officer. Can you please restate your name for the record?
Yep, Jonathan Steppen.
Officer Steppen, are you currently employed?
I am.
And who is your employer?
I am now with the city of Huntington Woods, but I was formerly at the Detroit Metro Airport Police Department.
Okay. And in what capacity are you employed as for the department?
Currently, I'm a public safety officer.
And previously at the other department?
Police officer.
And for how long at the previous department were you a police officer?
16 years.
Were you employed in this capacity as a police officer on February 23rd, 2021?
I was.
And did you work the state?
I did.
And did you work the state by yourself or with a partner?
By myself.
On this day, were you working in full uniform or modified uniform?
Full uniform.
And were you on foot patrol or in a scout vehicle?
Scout vehicle.
Was this scout vehicle marked?
It was.
Semi-marked or fully marked?
Fully marked.
And did your duties on the day of February 23rd, 2021 take you at or near the location of North Terminal, Upper Terminal Drive?
It did.
Is that located in the city of Romulus, County of Wayne?
It is.
Okay, what's at this location?
At that location is the, again, the North Terminal at Detroit Metro Airport.
And while at or near this location, did you observe something that drew your attention?
I did.
What did you observe?
I observed a unattended vehicle curbside in front of the terminal.
Okay, and when you made this observation, were you working in your capacity as a police officer?
I was.
For the airport?
Yes.
Okay, upon making this observation, what, if anything, did you do?
The vehicle was in a no parking zone. Exited my patrol vehicle, checked the interior of the vehicle from the exterior with the aid of my flashlight to see if there's any occupants in the vehicle. And there was not.
Okay, Upon making that observation that there was no occupants in this vehicle, what, if anything, did you do?
Due to it being in violation of the prohibited parking rule there, I requested a tow truck to impound the vehicle, and I returned to my patrol car to start writing the vehicle a prohibited parking citation.
Okay, now where exactly was this vehicle parked?
It was parked in front of the, at the time, it was called the North Terminal, now the Evans Terminal. It was parked directly in front of the terminal.
Okay, and it was left unattended.
It was left unattended.
And why did you call for a tow truck?
Again, because it was parked in a no parking zone.
And is that a ticketable offense?
It is.
Okay, now what occurred next, if anything?
Next, called for the tow truck, Martin's Towing, to be specific. Martin's Towing arrived and impounded the vehicle.
Okay. And did you observe that?
Yes, I observed the impound.
And can you describe what you mean by they impounded the vehicle?
So the tow truck basically hooks up to the tow or to the vehicle that's in violation, and depending on what stage it is, they'll sometimes just hook up to it. Sometimes they'll lift it. I can't recall if this particular case if he lifted it, but I can confirm that he did impound the vehicle.
Okay, and upon observing that impound, what, if anything, did you do?
So next, completed the citation, checked if the vehicle was unlocked, which it was, and at that point, I conducted an inventory search of the vehicle.
Okay, and upon conducting an inventory search, did you discover anything?
Yes, I did.
What, if anything, did you discover?
In the interior of the vehicle, the center console to be exact, I located a Smith & Wesson M&P pistol.
Okay. And can you describe this weapon?
I don't recall what it looked like other than it was a pistol due to it being 3 years ago.
Okay, now upon making this observation, what, if anything, did you do?
Next, I secured the pistol.
Can you explain what you mean by secure?
So I removed the pistol from the vehicle and then locked it in my patrol car.
Okay, was this pistol loaded?
Yes, it was.
Okay. Okay, now after securing it in your vehicle, what, if anything, did you do next?
Next, I checked the vehicle, or I'm sorry, I checked the pistol, its status to make sure it wasn't stolen. It was not stolen, and it came back registered to a crystal lot.
Okay, and what, if anything, did you do next?
Next, I checked the license plate of the vehicle. The registered owner was Frank Michaud Jr. After I checked him in lien, I checked.
I would object to hearsay. I don't know. Sounds as though the officers testifying to. I don't know what the basis of his testimony, knowing the owner of the vehicle.
I'm not really following the objection, Judge. I don't. What's the hearsay? He said he's objecting to hearsay. So what is the hearsay? There's no statement.
Right. So perhaps there could be some greater foundation as to how the officer knows who the owner of the vehicle is. Did he watch somebody purchase the vehicle? I presume no, but I presume the officer is relying on a record, and so I'm objecting to hearsay. That's a presumption, and if he's watched somebody purchase the vehicle, I will stand corrected. But he can only testify to personal knowledge.
And Judge, I believe he is testifying to personal knowledge. He conducted a lien search, and it came back registered to the individual Frank Michaud.
I believe Mr. Sullivan's objection was requesting a more greater foundation before we get to that conclusion. Mr. Sullivan?
Yeah, he didn't testify that he did a lien search. He just testified as to who the owner of the vehicle is. So then my objection is to, if he did a lien search, my objection is to hearsay.
Okay, I could lay a better foundation.
Yes, sir.
Officer Steppen, after you conducted a lien search in regards to seeing who the registered owner is, what did you do next exactly?
I checked if the registered owner.
What did you check?
I checked if the registered owner had a concealed pistol license.
How did you do that?
Through lien.
Okay. And Who is the registered owner of the vehicle after you conducted a lien search?
Frank Michaud Jr.
Again, I'm objecting to hearsay. It also seems there's some confusion about the officer. I think he's actually testifying about the owner of the weapon. He's testifying about the owner of the vehicle. I'm not sure exactly where all these things are coming from. They're all coming from me, but I am objecting to hearsay.
As to the gun or as to the car, as to both?
As well.
Your objection is that he relied on lien as to the owner of the car?
Correct.
Okay.
Judge, my response is this, it's not lien, or it's not hearsay. There's no out-of-court statement.
Lien is definitely an out-of-court statement that's being used for the truth of the matter asserted.
But
as to the owner of the vehicle or the owner of the gun.
I'm sorry, Mr. Sullivan. I thought your objection started as to the ownership of the vehicle. I didn't hear you object when Officer Stimpin testified as to the ownership of the gun. So I'm with you on. No, I'm looking at you because you opened your mouth and I just didn't want to interrupt you.
I didn't want to interrupt.
No.
Judge. When the officer was asked the questions again, he backed up to the owner of the gun, and then the questions proceeded with, how did you know the owner? And so, you know, I suppose I'm objecting to both, but the first objection, you're correct, is as to the owner of the vehicle, and I think that that's where the lien search is coming in. I don't know how the officer is checking the ownership of the gun, so if I welcome further foundation, but if it is a lien search, then I am objecting. I think the lien search is an out-of-court statement, and it's certainly used for the truth of the matter asserted in the lien inquiry, lien response.
Anything else, Mr. Mohammed?
I don't believe it is hearsay, and I don't think it's being offered for the truth of the matter asserted. It's just him performing an investigation, and he's testifying to his personal knowledge as to what he was doing. It's not being offered to show that this individual exactly did not have was not the registered owner, but it was just more into his investigation. And I don't believe lien is considered hearsay.
Anything else, Mr. Sullivan? Your objection is overruled. Officer Stimpin, you may answer the question if you recall the question.
Can you please repeat the question?
So after you conducted a search and you discovered that the weapon was not registered and the vehicle was not registered, or who the vehicle was registered to, what did you do next?
So after the vehicle was running lien and it returned to Mr. Michaud, I checked if he then had a concealed pistol license, which he did not.
And by he, you're referring to Frank Michaud?
Yes, the defendant.
Okay, now what occurred next, if anything?
After the pistol was secured in my patrol vehicle, I can't recall how exactly down to the minute when he came out, but the defendant eventually exited the terminal and then approached us as we were standing with the impounded vehicle.
Okay, and by that individual that approached you, do you see that individual in the courtroom today?
Yes, it's the defendant sitting at the defendant's table.
Can you please point to that individual and point out an article of clothing that individual is wearing?
He's wearing a white button-up shirt.
Your Honor, can you please let the record reflect that the witness has pointed to and identified the defendant?
Yes, sir.
Thank you. Now, what occurred next, if anything?
I asked Mr. Michaud if he drove the vehicle up to the airport that day.
And what was his response?
He stated he did.
Judge cannot.
What?
I place an objection on the record?
Hold on one second. Yes.
Just that the Mr. Michaud, as he
at the onset of our hearing, Mr. Michaud introduced himself to Your Honor as the trustee of the Frank Michaud estate, beneficiary, excuse me, of the Frank Michaud estate. And so we just want that objection.
What's the objection? I'm sorry.
That I am not the Frank Anthony Michaud that he is referring to, which is a fictitious entity, a persons, which is a corporation, that I am the beneficiary of that corporation, that said estate, for the record, and I appointed you as trustee of that. I'm not a United States citizen. I am not the 14th Amendment citizen. The corporation, artificial person. I am a natural person, a flesh and blood living man on the land, for the record.
Mr. Sullivan, the court will note your objection for the record and will indicate that the way that this file was received by this court is State of Michigan versus Frank Anthony Michaud. The court has not received anything to change that caption. So if Officer Stempin refers to Mr. Michaud as Mr. Michaud, we will understand it to be as Mr. Michaud has identified himself at the beginning of these proceedings.
I understand, Judge, and I think identity is, something that Your Honor can make a ruling on. We're just noting an objection for the record.
Understood.
And
Thank you.
I have to object to that because I have sent in my authenticated birth certificate, which is authenticated, giving me full faith and credit from the United States of America, Secretary of State John F. Kerry, letting you know that I am the authorized representative of this state that you are administrating over, for the record. I also sent you a UCC lien. If you need to see my UCC lien, the Michigan that I have filed in Michigan means that I am the lien holder of this estate, as well as my commercial security agreement, as well as indemnity bonds or any other information you need. I have put it on the record, for the record.
And Mr. Michaud, the court has acknowledged Mr. Sullivan's objection and will treat it as an ongoing objection, but has indicated that inasmuch as the complaint received in this case identifies you a specific way, the court will accept Officer Stempin and anyone else to proceed in that manner. So Officer Stempin, your response to the question.
Officer Stempin, this individual that you pointed out here in the courtroom that approached you on that day, what was said to you by him?
Again, I asked him if he drove the vehicle up to the airport. He said yes. I then asked him if he drove it by himself or if he drove with someone else, and he said he drove the vehicle by himself.
Okay. Did this individual that you identified here in court ever produce to you a CPL license?
He did not.
Nothing further for this witness, Judge.
Thank you. Mr. Sullivan.
Thank you, Judge. Good afternoon, officer.
Good afternoon, sir.
It's your testimony that you conducted an inventory search in this case, correct?
Yes, sir.
And you performed the inventory search prior to the vehicle being towed, right?
That is incorrect.
Oh, it being impounded?
I conducted the inventory search once the vehicle was impounded.
Okay. So I'll rephrase. You conducted the inventory search pursuant to the car being impounded.
After the car was impounded, yes.
It's the department's policy that when a car is impounded, it needs to be inventoried.
Correct.
And so there are policies from the Detroit, what is it, the police, the Detroit Metro Airport Police issue some policies regarding inventory searches.
Yes.
And those policies provide that when a car is being impounded, it needs to be inventoried.
Yes.
Okay. You said that you, well, I don't think you said, but you started the search at the passenger side of the vehicle, right?
I don't
Objection, assuming facts not in evidence. That was never mentioned today.
I don't know.
Objections overruled. You may answer the question.
I don't recall.
Okay. Just a moment. Officer, your testimony earlier was that the car is impounded.
Yes.
And it was impounded, I think your testimony is that it was impounded when you conducted your search.
Yes.
And let's talk about the definition of impound. When we say impound, that could be as simple as lifted up onto the back of the tow truck.
I'm not sure what your definition is, but the departmental policy is as soon as the tow truck makes contact with the said vehicle, it is impounded.
Okay, thank you. That's my question is not as to my definition, but as to yours. So in this case, the tow truck had made contact with the vehicle in question.
Correct.
And I believe that your testimony earlier was that you don't remember whether the car had been lifted up or not. Is that correct?
Correct.
But you just remember that there was enough contact.
I remember it was impounded.
Okay. And you don't remember the order of what you searched first?
No, sir.
Do you remember where you found the gun?
Yes.
You found it in the center console, correct?
Correct.
And that center console was closed when you found it in the center console?
I don't recall.
Okay. Do you recall whether you were entering the vehicle from the driver or passenger side?
Objection, relevance. I was, and knowing which side you entered the vehicle to conduct this inventory search relevant.
Judge, I think that the procedure that the officer is following when conducting inventory search is highly relevant. The officer testified that there is a policy, and so I'm just wanting to get a little bit more of a sense of how the inventory search is conducted and whether it's conducted according to policy.
Your objection's overruled. You may answer the question if you recall the question.
I do not recall which side I started on.
Okay. During your search, you crossed paths with a pair of designer sunglasses.
Objection, relevance.
I don't believe that Mr. Sullivan was done with his question yet. Mr. Sullivan?
Thank you, Judge. My question is that at some point during your search, you came across a pair of designer sunglasses. Is that correct?
I don't recall.
Is there a list that you can refer to?
Not on me. I do not have one.
Did you generate a list in the process of conducting the search?
There was a toe tag generated.
So let me ask the question a different way. As you went through the vehicle, did you make a list of the things that you found in the vehicle?
I don't recall, but I should have, yes.
You are testifying that you should have made a list of the things that are in the vehicle.
I don't have the toe tag in front of me, so I can't testify to it.
Okay. You would agree with me that your policy is to complete a toe tag?
Correct.
And if a toe tag is not completed, that would be in a violation of your policy.
I can't speak to that.
Well, you just testified that it's policy to complete the toe tag.
Correct.
Okay. Would reviewing your report refresh your recollection as to whether you completed a tag?
I can take a look.
But may I approach?
Yes, sir.
I'd like to see it.
First, you're opposing counsel for the record. May I approach?
Yes, sir.
Officer, I'm handing you a report. Okay. Tell me if you recognize that.
I do.
Is that your report?
It is.
Take a moment, review it. Let me know if it refreshes your recollection as to whether you completed a toe tag.
Okay. I don't believe it says on there.
I'm gonna direct your attention to the very last line here. This says the inventory search was documented on body worn camera.
Correct.
Does that mean that there is not a toe tag that's completed?
That is incorrect.
Okay, so your testimony is that it's inconclusive as to whether there's a toe tag completed?
Correct. Unless I can see it, I can't testify to it.
Okay, but you wrote in your report, the inventory search was documented on body worn.
Correct.
And it's fair to infer from that that it's not documented anywhere else.
I'm not going to agree with that.
Okay. But you, at this point, you can't testify to whether you completed a toe tag.
No.
He's answered, Judge, he's answered the question like multiple times. I don't know how many times.
I'm moving on. I'm sorry, Judge.
No, you're fine, Mr. Sullivan.
Do you recall coming across several pairs of shoes in the car?
I don't recall.
No list that you can refer to?
No, sir.
Do you recall coming across an umbrella?
I don't. I can't testify to that. I don't recall.
No list that you can refer to?
No.
You would agree that the purpose of an inventory search is to document the contents of the vehicle?
Correct.
So that when the vehicle is released to the owner, this prevents or protects the department from liability for stolen or missing property.
Yes.
And so the owner can see the list of things that's been inventoried at the time that the car was impounded. You would agree? And you can't tell me at this point whether that list was ever generated.
I can testify that it's per my report that it was documented on body worn camera.
But that's not, your testimony is that's not the police's policy, correct?
Objection, he's already mentioned, Judge, that he cannot testify to that.
That he can't testify to the policy?
No, not that he can't testify. He can't testify to everything that's in the policy. I mean, we don't, it could be hundreds of pages long. He can't testify to everything. He's testified to what he knows in his personal knowledge.
Hold on one second. Mr. Sullivan, your response to the objection?
Judge, I'm just asking about, I'm not asking about the entire contents of the policy, just sort of one provision of the policy, which I believe he's already testified to, and so I'm just looking for clarification. I believe his testimony was that policy dictates that he completes a tow card.
Your objection is overruled. You may respond to the question if you recall the question.
Can you repeat it, please?
Your testimony earlier is that the police policy is that you complete a tow card.
Correct.
The police policy is not that you document the contents of the vehicle via your body camera.
I can't speak to the specifics of the policy, whether it includes the body camera or not. Like the prosecutor states, the policy is quite extensive.
Are you aware of any instances when somebody goes to pick up their car from the impound lot, and upon picking up their car, they also receive a copy of your body worn camera? To your knowledge, has that ever happened?
Objection, relevance.
Judge, I'm again, my questions are about the purpose and the intent of an inventory. And if the officer doesn't quite remember whether or not the policy allows for the body worn camera to be substituted for a tow card, well, then maybe the officer will remember that sometimes people receive the body worn camera in lieu of a tow card.
And
when
I'm
they go to pick up the car.
Respectfully, I'm also going to be objecting as to speculation.
I asked if he had, to his knowledge, I'm not asking him to speculate, I'm asking him to his knowledge. If he says he doesn't know, then I'll move on.
Your objection is overruled. The specific question is, are you aware of any instance where someone goes to retrieve their car, right?
That was my question.
A specific instance, not some random general question, correct?
I'm not asking him to speculate.
Right.
I'd prefer that he testify whether he's aware or not.
Do you recall the question, Officer Stempen?
I'm not aware of that happening.
Okay. Just a moment, Judge.
Yes, sir.
Officer, in your experience, when you complete a toe tag, you enter that tag into evidence, correct?
It's entered into the Columbus system.
Okay, it's turned over to the prosecutor.
I can't testify to that. I can just testify that once it's logged, it goes into the Columbus system.
What is the,
The Columbus system is was the report writing system.
The report writing system.
Correct.
So it's entered into the same file with all of the reports and other evidence which is generated in the case.
I'm not sure. Once I enter it, I'm not sure where it goes. I can tell you that it gets impounded or input into the police database.
And that's per your policy, is that it gets entered into the database.
Our policy is that it gets entered, yes.
Thank you. Judge, may I approach
Approach whom?
the witness?
Thank you.
Sorry, I've previously shown to opposing counsel a video, which I'd like to approach the witness with.
You may approach.
Officer, I'm showing you a video. Okay. Do you recognize this?
Just for the record, I'll stipulate to the introduction of any video. In relation to this case, in regards to his body worn camera, I'll just stipulate.
Stipulate to the court receiving the body worn camera video.
Correct. Judge, I wasn't intending on admitting it into evidence. I was just going to ask the officer a few questions about the video. Are you able to identify this video?
Yes.
This is your body worn camera.
It appears so.
And this is your conducting what you call an inventory search of the vehicle.
Yes.
here we see you opening a shoebox.
Okay.
Is that fair to say?
I'm not sure what that is. It's a box, I can tell you.
Okay. When you open that shoebox, that's a place where you're anticipating there might be things hidden.
I'm not sure what hidden.
Okay. You want to make sure that there's no narcotics in the car before you impound it?
No, that's not a point of inventory search.
Okay. I'm gonna continue playing the video.
Okay.
Okay, in the portion of the video that I just played, you open a toiletry bag, correct?
I'm not sure what that was.
It's a small compact bag in the back of the car.
Yes.
You unzip it, you shine a flashlight around inside, and you said brushes.
Okay.
Is that correct?
I couldn't hear.
Okay. You didn't write down any of the things that you found in the bag?
Not at that moment, no.
And you didn't, certainly didn't inventory the entire contents of the bag?
I can't testify to that.
Okay. You didn't remove anything from the bag?
I don't recall.
I'm going to show you one more portion of the body on camera.
Yes.
I don't believe it's 1 second.
Okay, in that portion of the body worn camera, you're opening the compartment where the spare tire is kept, correct?
Correct.
You removed something from that compartment and you threw it into the truck.
It looked like something fell.
Okay. But do you know what that item was?
No.
You didn't document it in a list anywhere?
I can't tell you if I did or not.
And then in the video we watched you close the trunk.
Correct.
You testified on direct that you ran a lien search to determine the owner of the weapon that you found?
Yes.
And the owner was a Crystal Watley?
Yes.
And that's consistent with something that Mr. Michaud told you, correct? Mr. Michaud told you that that his girlfriend borrowed the car.
Objection, that was never raised at any point during any testimony, from my knowledge. He learned that from conducting a lien search, is what I recall, Judge. I believe that's a misrepresentation.
Judge, my understanding, and I've been practicing for a few years, is that I'm allowed to ask questions on cross-examination, which extend beyond the scope of the direct examination. Defense attorneys oftentimes do independent investigation, and this leads to questions that I sometimes like to ask on cross. And so please correct me if I have that wrong, but I don't think that I'm limited to the scope of the direct examination.
Judge, I'm just saying I think he's misrepresenting his words. He said he learned that information based off of a lien search, is what I recall. It was never through the words of anybody else. That's what the testimony today has reflected in. That's, from what I recall, that's what he said. I'm incorrect, I withdraw, but pretty sure that's what he said, that it was, he learned that through a lien search.
Your objection's overruled. I believe the question was the lien search and through something Mr. Michaud said to you.
I'll back up and lay further foundation, Judge. You had a conversation with Mr. Michaud, correct?
Yes.
You confronted him about the gun that you found.
I spoke to him, yes.
He told you that he believed it was his girlfriend's gun.
I don't recall. If I can take a look again at my report, I might be able to tell you.
Good man, bro.
Yes, sir.
Thank you, sir.
Let me know when the memory is refreshed.
Okay. Okay, I believe I'm ready. Can you repeat it just so I make sure I answer it correctly?
My question is, did Mr. Michaud tell you that he believed the gun belonged to his girlfriend?
Let's see here. Yes, he said that, yes, he stated that the gun may belong to his girlfriend,
Okay, I'll take a look.
Miss Wadley.
So that was consistent with what you learned in Lee.
I'm sorry?
That was consistent with what you learned in Lee.
Correct.
Just a moment, Judge. I apologize. Your testimony earlier is that you don't recall whether the center console was open or closed when you conducted the search.
Correct.
Would an opportunity to review your body worn camera refresh your recollection as to whether you had to open the center console?
Yeah, let's take a look.
Does that refresh your recollection?
Yes, sir.
Do you recall whether you had to open the center console in order to locate the gun?
In that video, I had it open.
Okay, so the center console was closed when you began your search.
Yes, according to the video, yes.
No further questions, Judge.
Thank you, sir. Any redirect?
Very briefly. Officer Steppen, you mentioned that you had conducted an inventory search on this vehicle. Why did you conduct an inventory search?
Because the vehicle was in violation of the prohibited parking and was impounded.
I'm sorry, can you repeat that? I misunderstood the first.
Yes. So can you repeat your question? I just want to make sure I answer it correctly.
Why did you conduct an inventory search on this vehicle?
Because the vehicle was impounded.
Okay, and why was it impounded?
Because the vehicle was in violation of the prohibited parking.
Okay, and is conducting an inventory search of a vehicle that's being impounded standard policy?
Yes.
Nothing further.
Thank you. Officer Stimpy, thank you for your testimony. You may step down.
Thank you.
Mr. Mohammed, your next witness.
No further witnesses, Judge.
Mr. Sullivan,
No witnesses, Judge.
argument.
Judge, the people moved to bind over on all counts. In regards to the CCW, Officer Steppen was performing his lawful duties as a police officer. He observed a vehicle that was just unoccupied and parked in a no parking zone. He then approached this vehicle and observed there was no occupants in the vehicle. Upon that observation, Officer Steppen then performed a search on the, well, prior to performing a search, he wrote up a citation for for parking in front of a terminal and it being unoccupied and it being not occupied by any individuals. He then contacted the towing company who came and approached, and they took this vehicle that they may or may have not placed it onto their vehicle. He then conducted an inventory search pursuant to that, and he discovered a firearm. Shortly after, he testified here that he conducted a lien search and observed that this individual, Frank Michaud, the defendant, did not have a CPL license. He further testified that this is the individual who was the registered owner of the vehicle. Furthermore, he testified that at some point after, he was approached by the defendant who he identified here in court, and that individual indicated to Officer Steppen that he was the only person who drove that vehicle there, and he was in possession of that vehicle. He's the one who brought that vehicle to that location. This vehicle was, a weapon was recovered from this vehicle, and the testimony reflects that the defendant in this case, who had an affirmative duty to produce a CPL license, failed to do so. Not only did he fail to produce a CPL license, he the lien search confirmed that he did not have one. Based on that, I believe the people have met their burden of probable cause, and we move for a bind over. In regards to the FIP charges, this individual has the burden to produce that he regained his firearm, his right to possessing a firearm. He failed to do so. People versus Perkins also reflects that he has failed to do so, and the burden is on the defendant to do that, not the people. So at this time, the people move for a bind over.
Mr. Sullivan.
Yes, Judge. Two arguments. One, I don't think the people have met their burden of probable cause as to Mr. Michaud being in knowing possession of this weapon. The testimony was that the weapon was discovered pursuant to an inventory search, and I'm going to get to that in a minute. I don't think this is an inventory search. But skipping that, the officer's testimony is that a gun is found in the vehicle, that it was not sort of readily apparent, it's not in plain view, but the officer had to open a center console in order to locate it, and that the gun is registered to an acquaintance of Mr. Michaud, and that was consistent with what Mr. Michaud told the officer. I don't think that establishes probable cause that Mr. Michaud was ever in knowing possession of the weapon, but that somebody else used the car, left something in the car. Mr. Michaud very well didn't know that had been left in the car. But I think that is a secondary issue. The primary issue here, Judge, is that the police are calling this an inventory search. And it's not controversial. We all know that a warrant is generally required in order to conduct a search. There are exceptions to the warrant requirement, but the government has the burden of proving the conditions of any exception are satisfied, and that's People versus Reed, 393 Michigan, Michigan Supreme Court opinion from 1975. The exception that I think the people are offering in this case is that for an inventory search, but the Michigan Supreme Court has been very clear in a case called People versus Toohey, that's spelled Toohey, a Michigan Supreme Court opinion from 1991, and I'll quote, "To be constitutional, an inventory search must be conducted in accordance with established departmental procedures, which all police officers are required to follow, and must not be used as a pretext for criminal investigation. Judge, I think that the search here is quite clearly a pretext for a criminal investigation. We've heard testimony that this officer is looking around in a bag, not making any notes as to what he's finding in the bag. He can't recall anything that any particular things that he's found in the car. He's testified that he made no list of the things that he found in the car. He testified that the policy would require him to make a tow slip or generate a list of the things he's finding in the car. And so I don't think that the people have met their burden, certainly as to whether or not the officer is following established departmental procedures as required by People versus Toohey, but also the nature of this search, looking into a spare compartment where the tire is stored, looking into this bag, but not making any notes as to what they're finding. I think that it draws the reasonable inference that these officers are looking for narcotics or a gun. They're conducting a criminal investigation, and they're not conducting an inventory search pursuant to established departmental procedures. If there was a tow slip, the officer has testified that it would have been included in all of the reports. And if the tow slip exists, then I think we have a discovery violation, Judge, because it's never been turned over. The people don't have it. I don't have it. And so whether this becomes a discovery violation or a violation of People versus Toohey, I think it's much clearer based on the officer's testimony that this is a violation of People versus Toohey and that the officer did not complete the tow slip. The officer's testimony agreed with me that he wrote in his report that the body-worn camera, quote, documented the inventory search, but that's not, but the officer also testified that that's inconsistent with the policy of producing a tow slip. And so, Judge, I think that this is an unconstitutional search, a search in violation of Mr. Michaud's rights. And so even the probable cause issue aside, the evidence of this gun should be suppressed. And then we definitely have no probable cause, Judge. The case should be dismissed. And I ask you to deny the prosecutor's motion for a bind over.
Judge, may I respond?
Yes, sir.
So Officer Stephan never mentioned that there wasn't a tow slip. He just said that he doesn't remember. And then in regards to, so what happened in this case, Judge, was that they observed a vehicle that was unoccupied. This is at an airport. There's nobody in the vehicle. They called for a tow truck company. The tow truck company came and they hooked it up. And then pursuant to standard policy of the police department, they performed an inventory search. There's nothing weird about it. It's standard between all police departments from my knowledge. Furthermore, this individual, the defendant, he exercised dominion and control of this vehicle, and this was displayed through the testimony of Officer Stephan. He said that the defendant told him that he drove the vehicle and he was the sole occupant. So this individual, the defendant, he exercised, at the very least, had constructive possession of the weapon. And so therefore, he had a duty on that day to produce a CPL license. He failed to do that. And the reason he failed to do that is because he doesn't have one. And that's what we're here for. The officer conducted a lien search. He confirmed this individual doesn't have a CPL license. So I believe at this time, Judge, the people have met their burden of probable cause, and we believe that at the very least, there is a question of fact for the trier of that. So I still move to bind over, Judge. Thank you for your time.
Thank you. This court was in receipt of a sealed copy of Mr. Michaud's record, and Mr. Mohammed proffered to the court People versus Perkins. And Mr. Sullivan, the court has had the opportunity to review the opinion, and it does indicate that the defendant bears the burden of producing evidence to establish that his or her right to possess a firearm has been restored. That being the case, the court is accepting the certified record that was tendered by Mr. Mohammed. The court also has had the opportunity to hear the testimony of Officer Stephan. And for purposes of this preliminary examination, we'll find that the people have met their burden. And we'll bind Mr. Michaud over as charged. Mr. Michaud, your next appearance date will be on March the 13th, 2024 at 9 a.m. That will be at the Frank Murphy Hall of Justice. Your previously entered bond with any conditions will continue. Mr. Mohammed, is there anything else on behalf of the people?
Nothing on behalf of the people, Judge. Thank
Mr.
you.
Sullivan, anything else on behalf of your client, sir?
Nothing else, Judge.
Thank you. That concludes this matter. That concludes this court's docket for the day. We stand adjourned.